log in and do the rest.
Okay, it's preparing to live stream the meeting.
All right, so then I'm gonna come to my end of the world. Log in and do the rest.
Okay, it's preparing to live stream the meeting.
All right, so then I'm gonna come to my end of the world. All right, it's done. Do the rest.
Okay, it's preparing to live stream the meeting.
All right, so then I'm gonna come to my. So you need to, okay, so up there where you're hearing all that feedback, you need to go in and now just click on those and turn that part of YouTube off, those tabs, and it'll stay on YouTube. That way you don't hear all that feedback. You need to go in and now just click on those and turn that part of YouTube. That what you're hearing there.
Are you talking to me?
No, it's the YouTube that's talking to you. So you need to get rid of those tabs. So minimize Zoom and you'll see the YouTube and get rid of it. Because that's where you get that feedback.
Okay, well,
I'll come down. I'll come down.
okay. That thing just keeps popping up and it was in my way. I've got out of YouTube now.
Okay, you got out of YouTube. Okay. Let's do this. We don't need the world. Judge Charles, how are you? I believe I'm just waiting on the attorney and maybe, I don't know if everybody else is ready.
Okay.
Okay, we are ready and the attorney is here and we'll let Judge Charles take over.
Okay. Thank you. All right. This is cause number CR 21-00185. State of Texas versus Mitchell Wade Ragland. We're here on the defendant's motion to recuse. Are the parties ready to proceed?
Defense is ready, Judge.
Stays ready, Judge Charles.
All right. My name is Alfonso Charles. I am the presiding judge for the 10th Administrative Judicial Region, and I have assigned myself to hear this case. So, Mr. Manning, you may present your motion.
Yes, Judge. At this point, I don't have any witnesses. I think the facts are stated and are undisputed. The timeline in regards to when the events happened. On July 22nd, 80-day Highsville filed a motion to withdraw and continue on time of probation. That motion had been filed on June 28th of 2022. Counsel for defendant followed up on the status of the signing of that motion on July 29th, 2022. And the court advised that the motion will be signed on August 1st. On or about August 3rd of 2022, the court was given an amended violation report, which included extrajudicial reports that were not admissible, alleging facts are disputed, and that those reports and any allegation violations that led to that in that report were abandoned by the state of Texas. Based on that, as well as additional information that was gathered in an in-conference meeting, the defense believes that Judge Mark will be unable to hear this case fairly and impartially based on his knowledge of inadmissible facts, and we request that he be recused on this case.
All right. Response from the state?
Yes, Your Honor. So it's the position of the state that the probation file is under the district court purview, and therefore anything contained in that file it is eligible for review by Judge Martin. The state did abandon those counts, and the state trust Judge Martin to discount the things that are not considered the things that the state does not proceed on. We did not ever come to have a hearing on this, but the state agreed with defense that those matters would not be presented as evidence against Mr. Ragland in that hearing. I don't believe that there's any conflict in Judge Martin knowing about something that's contained in the probation file and not considering it if the state chooses to abandon it or not proceed on it.
Mr. Manning, how is this different from, like, say you're in a non-jury trial or even in a revocation hearing and the state moves to offer something and the judge has to review it and then the judge determines it's not admissible? Case law presumes that the judge in those situations is able to disregard that. How is this different?
Absolutely, Judge. The reason this is different is the defense believes that Judge Martin has predetermined without a presentation of the evidence, whether that's the admissible evidence or inadmissible evidence, that Judge Martin has made a predetermination on what is going to happen to my client for his revocation without first hearing the evidence that's presented by the state. And like I said, those indications were made in an in-chambers conference with Judge Martin and the state when this issue was first raised. And so, you know, that's our position, is that his mind's already been made up as to what should happen to Mr. Ragland. And unfortunately, those stem from cases or charges that were dropped in an out-of-state incident. And so once that bell's been rung, it can't be unrung. He has some technical violations, but the reason for the technical violations were the fact that he was unable to be here to do his conditions of probation as required by the court. And so no matter what way we cut it, that evidence about him being in jail in another county, being held on other alleged offenses that have since been dismissed, that is going to affect his ability to hear this case and rule on a just, fair, and impartial manner.
Anything further by either side?
I would just say, Judge Charles, that I was in that in Chambers meeting as well, and I would characterize Judge Martin's comments a little bit differently than Mr. Manning has. In my opinion, which I understand is different from Mr. Manning, in my opinion, Judge Martin did not indicate a final outcome that was predetermined. No numbers or potential sentences were discussed. I believe there was, some comment along the lines of this doesn't look good, but that could be said in a number of cases, and I don't think that in and of itself, that comment predisposes an outcome before a hearing's been happening.
All right. Anything further by either side?
Nothing from the defense.
Nothing further
Yep.
from Kate.
Okay, just give me one moment. All right, the court has had a chance to review the motion, listen to the arguments of counsel, and the allegations made. Court is going to make the following findings. Court finds the motion was properly filed and is verified. Court finds that it does state grounds that, if proven, could justify the recusal. However, the court finds, based on what was presented today, that the evidence does not substantiate the need to recuse Judge Martin. Under case law, a judge, when he or she is hearing a matter and is serving as the trier of fact, is presumed to not give any relevance to inadmissible evidence. And there's been nothing to indicate Judge Martin would not be able to do that. So based on what was presented, I'm going to deny the motion to recuse. I'll prepare an order here in about 2 to 5 minutes and email it to Ms. Barker, and y'all can proceed. So if nothing further, we are adjourned. Thank you all.
All right, council, remind me who we have today in the courtroom that we're going to be having hearings on.
Judge, I believe we've already resolved Mr. Ragland's, Judge Charles denies the motion to recuse. So we request to be set up as a docket for November 29th. I began speaking to the state about a possible resolution. So we'd ask to be set up for that date.
All right, court will set Mr. Ragland CR 21-185 for contested hearing on November 29th at 1:30. And I think on that day, let me see where we're going to be. Looks like we'll be in the JP2 courtroom.
Yes, sir.
Unless we get fixed, which they're going to start on the roof on Monday, so probably not likely, but maybe. Mr. Schmidt, or you?
Agreements with all. And then it'd be really nice to see them this week for Robert without the hearing. And some of the big company, so I expect.
I saw the return of service followed by the sheriff's office. Said that he served her, didn't say where he served her, just said by email, but you talked to her, so she's aware of the.
I emailed him to her. Files earlier and then talked to her.
She may, I wonder if she reported to the jail. I'll ask Miss Tabraham, she's probably watching. Oh, of course she's watching, she's right there. Will you contact Miss Lee and make sure that she's not out at the jail, expecting us to have a hearing out there?
You have a couple of people here too.
Yeah, let's do it.
Bill Hall.
I'll meet you after. Well, I'll meet you a quarter of the way, you go 3/4. All right, this is cause number CR 21-293, State versus Philip Andrew Hollister. Mr. Hollister, if you'll raise your right hand, best of your ability. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Mr. Hollister, you appeared before the court on April 14th of 2022. The court heard the evidence, found that there was sufficient evidence to convict you of the third-degree felony offense of driving while intoxicated, third or more. The court accepted the plea agreement that day that you had reached with the state, assessed your punishment at 10 years confinement in the Texas Department of Criminal Justice. The court also assessed a $5,000 fine, and then the court suspended that sentence and placed you on community supervision for a period of 5 years. It was during your period of community supervision that the state has filed its motion to revoke community supervision, and they have alleged in 5 separate counts ways that you have violated your terms and conditions of your community supervision. Do you believe that you've had enough time to discuss these allegations in this motion with your attorney, Mr. Schmidt? And do you feel like Mr. Schmidt has provided you competent representation and you're pleased with him?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today with him that you do not understand? And Mr. Schmidt, do you believe Mr. Hollister to be competent today?
I do.
And you've explained to him his rights as they pertain to this motion and the counts therein?
Yes, sir.
And you believe that he understands those and he's entering his plea intentionally, knowingly, and voluntarily today?
Yes, sir.
And does he waive the formal reading of the state's motion?
We do.
And he intends to plead true to all counts?
Correct.
All right, Mr. Hollister, I see that the plea agreement that you're asking the court to approve is that upon a finding of true to the violations alleged, that the court revoke your community supervision and assess your punishment at 8 years confinement in the Texas Department of Criminal Justice, with you receiving 99 days credit towards that sentence for the time that you've spent in jail previously, and you being ordered to pay the remaining cost of your fines, court costs, and reimbursement fees. Is that your understanding of the plea agreement?
Yes, brother.
Any questions about that?
Yes.
Okay. All right, then, Mr. Hollister, then I would ask you at this time, how do you plead to counts 1, 2, 3, 4, and 5 as contained in the state's motion? Are those counts true or not true? And are you telling the court that each one of those counts is true because in fact it is true? You're not just saying that to get a certain plea agreement?
No, that's true.
Okay. All right, the court will accept the defendant's plea of true to each count alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of true?
Okay.
All right, that's admitted. The court does take judicial notice of Mr. Hollister's judicial confession. Anything further from the state? From the defense? Okay. All right, Mr. Hollister, based on your plea of true, the court will follow the plea agreement in your case. Court finds that you have violated the terms and conditions of your community supervision. The court hereby revokes your community supervision, assesses your punishment at 8 years confinement in the Texas Department of Criminal Justice. Court orders you to pay the balance of your financial obligations on your $5,000 fine, $127 court cost, and $140 reimbursement fees. And the court awards you 99 days credit towards your sentence for the time that you have spent in jail on this cause. All right, Mr. Hollister, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Deputy Everett's going to fingerprint you. Okay. Mr. Alexander. Are you Randy Lynn Alexander?
Yes, sir.
Mr. Alexander, just to the best of your ability, please raise your right hand so I place you under oath. Mr. Alexander, your other hand. It's all right. It's okay. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right. I'm not sure if a left hand invalidates an oath any more than a right hand, but whatever. It's a habit we do. So, Mr. Alexander, you appeared before the court on December 18th of 2018. Court heard the evidence on the charge of unlawful possession of firearm by felon. The court found that there was enough evidence to convict you of that offense on that date, and the court entertained a plea agreement and followed a plea agreement. The court assessed your punishment at 10 years confinement in prison, suspended that sentence, placed you on community supervision for 5 years, and ordered you to pay a $1,000 fine. Since the entry of that order, the state has filed a motion to revoke your community supervision, and they have alleged in 6 separate counts ways they believe that you have violated. Have you had an opportunity to review that with your attorney, Mr. Schmidt?
Yes.
Do you have any questions about that Mr. Schmidt's been unable to answer? Are you happy with Mr. Schmidt as your attorney?
Yes.
And is there anything about the paperwork that you've read over and signed today that you do not understand? Mr. Schmidt, do you believe Mr. Alexander is competent today in entering his plea intentionally, knowingly, and voluntarily?
Yes.
And you've explained to him his rights as they pertain to this motion?
Yes.
All right, Mr. Alexander, and I'm sorry, let me ask, does your client waive the formal reading of the state's motion?
Yes.
All right, Mr. Alexander, then as to counts 1, 2, 3, 4, 5, and 6 in that motion, are those counts true or not true? And Mr. Alexander, has anybody threatened you, forced you, pressured you to plead true to any of these counts today? To plead true to any of these counts today alleged in this motion?
Right.
Has anyone threatened you, forced you, pressured you to plead true to any of these counts as they have been alleged in this motion? Court will accept the defendant's plea of true to each count. Any objection to the admission of the defendant's waiver of rights to plea of true?
Okay.
That's admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
No.
All right, Mr. Alexander, based on your pleas of true and the evidence, the court will find that you have violated the terms and conditions of your community supervision. The court will follow your plea agreement in this case. Court hereby revokes your community supervision, assesses your punishment on the charge of unlawful possession of firearm by a felon, a third-degree felony, to 3 years confinement in the Texas Department of Criminal Justice Institutional Division, and orders you to pay the balance of your financial obligations. And the court awards you 73 days credit towards your sentence for the time that you have spent in jail on this cause. And Mr. Alexander, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Deputy Everett's going to take your fingerprint. You can come on up here. Visit with him. All right, Mr. Schmidt, anyone else you ready on?
Judge on Matthew Cullen, state and defendant have agreed that defendant Collins used $1,000 cash security based on our
So that's Coleman.
Cullen.
And you said agreed at 40,000?
Yes, sir.
Okay, all right, the court will grant the bail reduction as agreed by the state to, and the defendant to $40,000. Is that cash or surety?
Yes.
Would you actually ask for no contact conditions with the victim? I'm sure they're on there, but if they're not, we would have to be added.
Any objection, Mr. Schmidt?
No.
All right, the court, if a no contact with the alleged victim in this case has not been ordered, the court will make that a condition of the pretrial release, which will be connected to the bail in this case. And I believe Ms. Taberham probably gave me all of those orders. Who are we ready on now? Okay. All right, Mr. Campbell, if you want to come up and have a seat with Mr. Schmidt. And if we need to move that out of the way, we can to give them more room. Thank you, sir. All right, this is cause number CR 19-108, State of Texas versus Robert Baker Campbell. We're set today on motion to adjudicate. And I find that Mr. Schmidt, you have filed a motion to withdraw guilty plea on behalf of Mr. Campbell. Is that correct?
Judge, we also filed it prior to that, but we were ready to see on the motion. I think that we took care of all of that.
Okay, and so the writ was filed under 1107-2. Okay. All right, so you can proceed.
Judge, at this time, I'll go ahead and call Ms. Shelby.
All right, Ms. Lee, if you'll come forward. Go ahead and have a seat in the witness stand. And can you see Ms. Lee at that vantage point, or we need to turn that? We can. Can we just see if we can turn that a little bit? Ms. Lee, hold it real tight. There you go. Ms. Lee, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, thank you. Put your hand down. Make sure, counsel, that we're speaking one at a time. Y'all know the rules. Ms. Grisham can only take down one at a time, so make sure we give each other ample opportunity to finish questions and answers before we move on. Yes.
And are you an attorney?
Yes, I am.
And are you licensed in good standing with the state bar of Texas?
Yes, I am.
How long have you been in attorney?
21 years.
21 years, and has your practice been in Texas the entire time?
That was the entire time.
Okay. And do you practice in the
Yes, I do.
Are you on the 20 or independence?
No longer, I was.
And when did you go?
February.
When did you get up to the court appointment?
February.
Of this year, 2022? And are you an attorney on the book list? Did you or were you going to represent a Robert Baker Campbell?
Yes, I was.
And you see Mr. Campbell in court?
Yes, I do.
Okay. And do you recall what the time frame of the representation of Mr. Campbell was?
If I
didn't get recruited as to.
yeah. So I was appointed to represent him on February 21st of 2019. And I completed on October 1st.
And did you maintain a file on Mr. Campbell in your office?
Yes, I did.
Okay, and you wrote that in the USC?
Yes, I did.
Okay. And does that file contain your practice notes, with the things you made in reference to your representation, Mr. Campbell?
Most of it, yeah, there were. I had some phone conversations. And that were not, when I had the file with me, so I didn't write anything down.
And do you recall what Mr. Campbell was charged with?
Aggravated assault, and that's in my account.
And during your representation, were you received from the DA's office in discovery in that case?
Yes, I did.
And did it have visual as well as your discovery?
Yes, it did.
And did you review that discovery?
Yes, I did.
And approximately how many times did you go over the discovery that was provided to you by the state?
Well. Few times,
Few times?
yes,
More than once, is what you're saying?
more than once.
Okay. And at some point in time, did you go over that discovery with Mr. Campbell?
Yes, I did.
Did you go over the defendant in person?
Yes, I did. Well, I went over the written discovery with him in person. I had not yet received the digital discovery. So we went over the written discovery on June 10th of 2019 in my office.
Where's your office?
At that time, it was in Terrell.
So he came to your office and you went to the written discovery.
Yes, we did.
And after that time, you see the digital discovery, is that correct?
Yes, I did.
Did you ever have an opportunity to review that yourself?
I did. I was able to review it myself.
Okay, do you recall what it was involved about?
What I can refer to my notes.
Yes, that's fine.
Okay, so what I have in my notes is I have reference to what I call video 1, which is 38 minutes long. And then I have reference to the 911 call.
And do you recall, I know it's been a minute, but do you recall viewing those videos yourself? Do you recall viewing them?
I've viewed the videos myself.
Did you ever view those videos with each one?
No, I didn't.
Okay. Did you discuss those videos with Mr. Campbell?
I don't have any of my notes, but I believe I did.
Okay, would that have been in your office?
He was in jail.
So he so he was out of jail when he first came.
No, when I first took on representation, he was in jail. Then he got out about a month later. Then he was able to come to my office. Then he missed the court date and ended up in jail.
Okay, do you recall what the date was that you missed as far as what was it?
It was August 13th.
And did you have any communications with Mr. Campbell, pertaining to that date?
He was present in my office when I got that court date. And then after that, I was unable to reach him by phone, but he actually had the arraignment date, because what we did was we waived arraignment and I set it for pre-trial. And I had him sign, I'd already gotten the date, so he got it and that he filed it. So he had the notice of his court date.
Gotcha. And were you in for physically on office?
Yes, I was.
Okay. And by your testimony, Mr. Campbell,
Mr. Campbell did not make it to court.
did you have any conversations about that with him after?
He called me on August 4th. Luckily, first I was notified by the office manager that he had shown up at my office because he realized he had missed court on August 14th.
So he came to your office and visited you, or you called?
He appeared at my office on August 14th. I was in court.
Okay, so you did not meet with him?
I did not. meet with him.
Did you speak with him at all?
I spoke with him several times on that day.
Do you recall the nature of those conversations?
I told him that he needed to turn himself in because he had missed court on August 13th. And that judgment my side had been issued. At that time, I also received word that his bond company had gone off of his bond. They had notified me on the 12th because he had not paid and rejected them, had bounced, and he had not been keeping in contact.
So do you believe that there was a release of surety from the bonds company prior to the 13th?
Yes,
Okay. And did you, you didn't have an opportunity to?
his number, I was unable to read. Mr.
At any time on August 14th and thereafter, did you relate to Mr. Campbell that the hearing had been set?
It had. Okay.
Okay. And did you relate to him that it had it?
I never told him that this hearing.
Okay.
I told him to turn himself in.
Up until October 1st, 2019, roughly how many felony jury trials had you conducted as a first year?
Felony, well, I think it was one.
Was that in Benedict County?
Yes, it was. If I have the date of it right, it may have been 2020 when I got that.
And did that go to a jury verdict? Do you recall?
It went to a jury verdict, yes.
And do you remember the name of the defendant that you represented in that case?
Jason House, right?
Prior to that jury trial in Benedict County, you had not conducted a felony jury trial?
No, I had not.
When you discussed the discovery with Mr. Campbell, did you go through, the possible defenses that he had to the charge that was?
Yes, because he brought one to me, he said that he did a self-defense.
He claimed to you that it was self-defense.
Yes, he did, I have it in my notes.
And
Yeah, I've written, like, so I have that he wanted to fight the charges. And then I have that he has a defense of self-defense. So it may have been, he told me, or it may have been that I determined it, because it was not like, you know, listening.
And did you ever review the law pertaining to self-defense and how it applied to particular facts in Mr. Campbell's case?
Yes, I did.
And did you ever discuss with him the legal ramifications of facts in this case?
On that day in my office, that was when we went over it, because I had already received discovery then. And I had my laptop and my stuff. And we spent the time to go over everything that I had.
And that was the first meeting in your office.
That was the first one.
I know you already testified to this, but could you remind me what date that was? Do you remember?
The meeting in my office was on June 10th.
After the June 10th meeting, did you discuss with Mr. Campbell any of the evidence of his defenses? Or was that the only time?
So after June 10th, I spent time looking into some other things that Mr. Campbell wanted me to look into, which I don't think he would want me to go into right now. And then I tried to reach him. And that's when I was no longer able to.
And at some point in time, after the June 10th and after the August 13th court date, when was the next time you saw Mr. Campbell that you could follow?
On August 27th,
And where was Mr. Campbell at that time?
here at the courthouse.
Was he in custody?
No, he just showed up.
Do you know why he showed up?
I just have in my notes that he just showed up. After, you know, that he was arrested, he was not scheduled to work.
Did you not have a conversation with him at that point?
I believe I did, because I think I told him, what are you doing here? You know, why didn't you turn yourself in? I advised him on for what to do.
And then obviously said that we did not discuss his case, we discussed the bonds that.
I believe that it's.
And after he was taken into custody on August 27th, did you have an opportunity to meet with him again?
According to my notes, that time I most likely saw him was October.
And that was the date of the entry of his plea.
Yeah, yes, it was actually set up to be for to get the bond reduced. And then we ended up having to do that.
So he said for a bond reduction in that office.
A bond reduction hearing.
And did you file that request?
I filed the request for the bond reduction.
And do you have, or do you know about when you filed that?
I filed that on, I believe it was. August 30th, I filed my written notice.
Was Mr. Campbell indicted at that point, or was he still unindicted? Or-
Mr. Campbell was indicted back on way before that.
Okay. And on October 1st, where was he at? Did you meet with him in the attorney participation room in the jail?
Yeah.
And approximately how long was that?
I don't have it written down.
You recall vaguely what, how long it was?
I talked to him at length because he was trying to make a decision that I was not. Like, I was talking to him about what this decision would be.
And at the time you were meeting with him, did you already, you'd already received the plea offer from the DA's office?
Yes, I have.
And when was the first time you would make that offer to Mr. Campbell?
I not say for sure, it may have been that date. Because in my notes. Yeah, I have to tell you, I did not know when I first worked on the ballot. Because I first received the plea on June.
You recall?
what I was told is that it was a long deferred about 10 years.
And you thought that's what you were.
Yes,
And when you relayed that plea offer, did he immediately accept the plea offer?
well, what I remember of the conversation, Mr. Campbell, so one of the things that you might want to know is that, yes, he had PTSD. And he had issues with being in jail. And he just wanted out of jail. I was intending to do a plea that day. So what I recall is that that's what it was like, just like, can I get out of jail? Will it get me out of jail today? If can you lose this hearing? And will I end up with my bond reduced as a result of this hearing? I was like, I cannot guarantee that.
At any point did you tell Mr. Campbell that the plea offer was only given for that? I think you accepted it and rejected it.
I do not recall that happening.
And did Mr. Campbell on October 1st reiterate to you his desire to fight against and start against him based on self-defense?
I do not think so, because I think that I was actually the one who get off on into this.
So at no time did you encourage Mr. Campbell to?
Not that I recall.
And do you recall that?
I do not switch my mind with the please, there are no.
Fair enough. And did you tell him that you didn't say that he would be sitting in jail on trial?
That I do recall saying. That was a likely outcome that I could not guarantee that, because it was part of us not being able to guarantee that the bond would be lowered. So I didn't say like, oh, you're gonna be sitting, I talked to our guy, Steve, and I said, he was asking me questions. And yes, I mentioned that I don't know if we're gonna get the bond lowered. I just do not know that. And if I cannot get the bond lowered, then, and you cannot pay it, well, the natural thing that would happen is that you would be sitting.
Right. Did you offer to proceed on the bond?
I did.
And when you met with him on October 1st, do you remember about what time of day it was?
It was before court, because I think at that time, it was where you had to put the rules with the jail visits and everything.
Did you have the plea paperwork ready to you?
I cannot remember. I know that I went over it with him whenever I did that.
As always is the case, you can always second guess your representation of a client, I'll go for that, but looking back, do you believe that you gave Mr. Campbell effective representation in this?
Yes, I did. I gave him very effective representation, because especially considering how hard it was to reach him, and that I was dealing with this investigation.
And do you think that there was anything in your representation that you could have done better?
No,
And if Mr. Campbell had rejected the plea offer, do you think you would have been prepared and able to go forward on the jury trial on a first degree felony?
it was a first degree. The second degree.
You sure of that?
That's what I have on the indictment. I'm not gonna say yes to the first degree, but I will definitely say yes to the second degree.
So you would be prepared on a second, or maybe not a first degree?
Maybe not a first degree, well, simply because I wasn't receiving, I don't get first degrees for in my other job.
So if he was indicted for a first degree felony, do you think that that appointment would have been concurrent?
If he was indicted on first degree felony, I think that it would have been where they didn't intend to, it's not appointed to me. But do I think I could have handled it? Yes.
But up until that point, you did not have a first degree felony.
No. I mean, that's correct, but I did not handle the first.
And could you explain why at that point? I mean, I think you said you've been practicing for 20-something years, so why did you not have the first degree felonies?
I've been practicing for 21 years, but I did civil until 2014.
Oh, I see. So you were practicing.
Oh, actually 2015 was prior to the civil one.
And are you doing first degree felonies now? in criminal
No.
case? Okay, that's good.
Ms. Heisel?
Please, just, for the record, I missed this one. On what day did you say you picked up the legal discovery?
I did not state the date. I did not have in mind those. When I picked up the digital discovery, I did actually try to figure that out to look for that. But as you know, you get the. It's often much different, much farther along.
If our records reflected September 9th, 2019, does that come out right to you?
That's when I find it, and that is the date.
And Ms. Lee, you testified that Mr. Campbell and you discussed, the self-defense claim, is that correct?
Yeah, in my office on.
Okay, and, on June 10th, when we all discussed that, did you go over in the paper discovery with him, statements of any witnesses?
Yes,
Did you ever make contact with those witnesses and, discuss with them their statement?
no, I didn't. Oh, I'm sorry. I did not with, so there were some. This got kind of messy. Because when I spoke to Mr. Campbell on the 14th, one of the witnesses was with him, and we actually spoke on her phone. The witness was actually the victim.
Okay, there were. I believe,
You're talking about, if you're talking about the two workers.
that's correct, I'm
I
talking
did
about
not,
a Mr. Lopez and a Mr. Cruz.
I did not make contact.
Okay, but you did discuss with Mr. Campbell their statement, their content.
Yes, we went over everything that was.
Y'all can take turns.
I'm sorry, please.
Your Honor, I possibly this.
Mr. Schmidt?
I don't know. Further questions.
Anything further, Ms. Heisel?
No, Your Honor.
All right, Ms. Lee, you may step down.
Thank you. Your Honor.
Is there any request to keep Ms. Lee here under the subpoena, or is she free to go?
Free to go as far as I'm concerned.
Ms. Heisel? Any objection?
No, Your Honor, I'm sorry.
Thank you, Ms. Lee. You're free to go.
Thank you. Your Honor.
Appreciate you. Mr.
I call Robert Campbell.
All right, Mr. Campbell, you'll go to the stand, please. Best that you can, raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Same thing I asked Ms. Lee to do. Just make sure you speak one at a time. Allow the attorneys to finish asking the question before you give the answer, okay?
Yeah.
Thank you, sir. Go ahead, Mr. Schmidt.
State name for the record. I'm sorry. I said state name for the record, please. Robert Baker Campbell, third. And Mr. Campbell, the conversation and the questions that I'm gonna ask and to mostly the representation between you and Shonda. And if we need to develop other testimony about the facts of the case, we can do that. But, do you recall, working with Ms. Lee on the case before you took the plea?
I don't remember meeting with her at all. I'm not gonna say that I didn't. I don't remember. My memory is not that in the world. But, I don't recall that. I remember meeting with her in the jail.
And when you met with Ms. Lee about this case, did you ever go over or you recall going over the evidence of the discovery in the case?
No, sir. All I know is that something about, there was two eyewitnesses. Told me that they were hurt work and I never heard what all was there until I got probably.
And you, did you ever speak with Ms. Lee about your self-defense plan? And the charge?
Yes, I think I did.
And were you, adamant with her that you were not guilty because you were defending yourself?
Yes, sir.
And did she, go over the witness statements and claim with you?
No.
Did she ever discuss with you, the law, with self-defense, and it pertains to the facts of your case? And when you tried to contact her, were you able to get her on the call or whatever and talk to her?
Contacted her, like she said, I don't know what the date was to be exact. She said, I think the 14th, 13th, 14th, something like that. The day after I was sport, she told me, okay, it's okay, I rescheduled it. That's how I knew to show up when I did.
So you showed up in court,
I don't know what day it was, 2 weeks later.
I think you said it was like August 27th.
If I did yes or no, I'm not.
And you were taking on custody that day.
Yes, sir.
And you were there because she told you that was the day that.
I was just.
I think that's what I'm talking. So that's the date she informed you when you talked to her that your case was reset. August 27th.
When I talked to her on the phone after I missed.
Yeah.
Yes, sir.
Did she tell you that she was taking care of it and reset it, or what did she tell you?
When I knew work would show up, I reset it. There would be right. I remember her telling me turn my Philippines.
Did she ever tell you that you had revolving offer case?
No,
Did she ever tell you that the judge should revoke your bond in court?
I didn't hear anything like that. Like I reported that day.
So when you showed up on August 27th, you believed that everything was fine.
Yes, sir.
And obviously they took you into custody. When's the next time you saw, Ms. Lee?
Like 5 days later, I remember that.
And had you talked to her about your bond issue prior to that?
Not that I recall.
Did you know, or did you see a copy of the motion to release your bond? That you planned to file?
No. I did, they were going to bump me out. We're gonna get locked out.
And so did you meet with her, October 1st, 2019?
That was the day that I signed to get out. Just
Right. And did you meet with her in the visitation room over at the
Yes.
jail? You remember about how long that meeting was?
that's a little bit, 30 minutes maybe, I don't know.
And at that time, did she relay to you what the plea offer was?
Yes, sir.
And was that the first time you heard the plea offer?
Yes, sir.
And at that time, did you tell her that you were not guilty and that you got a self-defense claim?
Yes, sir.
And did you, have a conversation about whether or not you should accept the plea offer?
Well, I wanted to know if I could go to court, what all I heard was. With I was hurt me worse.
So you discussed it with the eyewitnesses.
She didn't know what they said, that's all. She told certainly my brother also.
But she didn't tell you that.
She did tell me that.
Okay.
Yes,
And did she urge you to accept the plea offer?
you told me, I didn't make a plea that day. They guaranteed that I would be in there at least a year. I mean.
Okay.
And
And did you discuss the option of going forward on your motion for bond reduction?
I don't remember anything about the law.
And so as far as you recall, that was just the regular docket date for you?
That just popped up. I don't remember ever even said, being told I was sitting on the top. I didn't know I was on the court. Again, I don't remember her telling me or me hearing that I was on the court based on documents.
And when she told you the plea offer was, did you feel like you were being pressured by Ms. Lee?
I told her I wasn't taking-
Say again?
I told her I wasn't making it, or that's when she told me that I'd be in jail for over a year.
Okay. Did she say anything else about accepting the plea? That you remember?
I mean, I'm trying to recall, tell me what it was.
And on October 1st, were you aware that it appears to me that the state had enhanced your offense to the first degree felony? That was not.
Well, that's a good one.
Uh-huh.
That was a really bad, but good.
Okay, I'm gonna have to double check on the plea, what the information.
So my understanding is be.
So when you had, did you believe you were moving to a further study of the felony?
It was $5.99.
That was your understanding at the time?
Yes, sir.
Okay.
I guess that was the first.
Right, and that was my understanding as well, but I don't have the whole thing in front of myself. Either way, did you tell Ms. Lee that you did not want to take the plea because you were not here?
Did I tell her that I didn't want to take the plea? I told her I wasn't guilty. I wasn't, she knew I wasn't really happy. I was going out there.
You just wanted that.
I wanted to feel like, I mean, I make that be in jail happy. Sure, when I was young, 18 years old, I was in jail for just silly stuff. You know, but I didn't make it happen.
And we've talked, you and I, quite a bit since we've met, and we've gone over some of the underlying case a few times, correct? Do you think that had you gone to trial with Ms. Lee, that you would have fared any better?
I would say I could got worse. I mean, I don't understand what it's really yet. But we mean if I went to court and she got me out of it,
Yeah, at trial, do you think that she would represent that? And why do you think that?
I just from sitting here listening to her today.
Well, prior to today, though.
She didn't act like she, I mean, I don't know how to put it. He wasn't interested in me being guilty or not guilty of gas thing. You know what I'm trying to say?
I do.
It was just like. He used guns to do whatever, you know, I just defended him.
Right, and so as far as you're concerned, you didn't have any confidence in the jury trial with Ms. Lee representing you.
No, not really.
And did you have the money at the time to hire your own attorney?
No,
So you had to rely on a court-appointed attorney, like you already know.
yes,
Okay. Now, obviously, you entered the plea,
yes, sir.
and you understand that, you know, we maintain you're not guilty to me, and you may have to mislead, but you entered the plea guilty before the court.
Yes.
Do you think that was a wise decision?
I know it was very good. If I had to do it again, there's no way I would do it.
But you're maintaining your innocence even as of today.
When I pulled that trigger, I was defending myself.
Do you think that if you had received effective representation, that you would have better understood the consequences of entering the plea at the time?
Yes, sir. Well, I think so.
Okay, and do you think that if you had had more effective representation, that you would have understood?
If I had somebody that seemed like they really gave a damn, Darn, excuse me. Yeah. That's what.
Ms. Heisel.
Just for clear, so Mr. Campbell, did this Lee go over with you that there were statements given by the eyewitnesses?
She said the statements, this officer said, the statements were heard worse than them.
Okay, so she did tell you that eyewitnesses had made statements.
Yes,
Did you ever see those statements?
not until my probation. I didn't see them, my probation, off the road.
Okay, and that was after the plea.
Yes, that's all.
And did Ms. Lee give you a verbal summary of what the statement said? Your Honor, I see.
Mr. Schmidt.
No.
All right, Mr. Campbell, you can step down. Let's talk about that judgment. So the indictment, the heading of the indictment says second degree felony, but the body charges a first degree felony because it's aggravated assault, deadly weapon with a family violence finding. I think
But judge, to make it a first degree, there has to also be a serious bodily injury, which this case does not have.
it has to be SBI, can't just be
Correct.
exhibition of a weapon.
Correct. That's my understanding of the law, is that it has to be a family member and cause serious bodily injury.
Well, let's take the time to do that real quick.
So going off, Judge, I'm going off, at one point in time, paperwork was prepared. Judgment, the last was the first degree felony. My assistant is very, initially was going to be that so much to be done. That's what it looks like.
Judge, under 2202B1, an offense under this section, is felony of the second degree, except the offense of the felony of the first degree if the actor using a deadly weapon during the commission and causes serious bodily injury to a person whose relationship is defined as. So my understanding is that it requires both elements.
All right, so the indictment is correct in the header and then the judgment's incorrect. Because the indictment says second degree felony, but the judgment says first degree.
Judge, I'm looking at the statutory history right now. It was amended September 2021, as well as September 21. I don't know if it was in 2019 or if it's different. I think that ultimately it would surprise me if it was not as a first, knowing that the street is not qualified to accept those cases. But I was going to talk to people about that.
Judge Meyer, who wrote both the state's file and the district clerk's file, makes me very confident that it's just an error on the judgment. This was indicted in the second degree. There is no first notice. In fact, I don't fully eligible for amendment based on the criminal history that I have. So I think the judgment should follow.
You know, the judgments does say it's a first degree, but the statute that cited is the second degree. So it's, if it's wrong in one place and not two. Nevertheless, go ahead, Mr. Smith. Okay. Any witnesses or evidence from the state? Argument, Mr. Smith?
Would, obviously, we've argued this case quite a few times. And I understand that none of it's made to the record. Under the circumstances, it's easy to want to be more important than a colleague. I generally don't like doing that. Because I know that they could easily do the same to me as well. However, I think that under the circumstances, Ms. Lee, although a fine person, she really had no business handling court appointments in 2019, probably not now. I think that the representation that's provided and based on the testimony, there's a high likelihood that she was probably more eager to get a plea done, so the case would not have to go to trial. But Mr. Campbell has steadfastly maintained his innocence as to me as well as to Ms. Lee, and ultimately took the plea. I think that as his testimony showed, that was a huge mistake. But that mistake, I think at this point, we're talking about a man's life. I think that if he's innocent, based on a valid self-defense claim, now we're looking at whether or not he should go to prison on a motion to adjudicate, up to 20, I guess, the judge is incorrect. My understanding is that the people I had was up to life. That's a significant and serious punishment for an individual who should have been in jail, in my estimation, to start with. And so I don't believe that at the point that the plea was entered, Ms. Lee ever been to a jury trial, particularly on a felony. I don't believe she was qualified to handle felonies. I don't believe that she was qualified to adequately advise Mr. Campbell of the potential ramifications of entering a plea or the ramifications pertaining to a potential jury trial as it pertains to his facts, as it pertains to his defenses. Ultimately, had he had adequate representation, I do not believe that he would have entered a plea, nor do I believe that he would have been found guilty in a jury trial. That's my professional opinion. I've made that point clear to court more than once. But under the circumstances, I understand that the court, if the court approves our motion, obviously it should be a high threshold, because if it isn't, then everybody has buyer's remorse who want to come in and try to get a second bite at that. And as courts where we don't file these very often, I don't think I've ever filed one in my career. We brought it to this court's attention. We believe that it's merit. We ask us to approve it and allow us to move on.
And I got a couple of questions. So a lot of this is speculation on Miss Lee's ability or inability to try the case. But factually, what do you believe her testimony and Mr. Campbell's testimony has borne out today? That she didn't advise him of his rights, that she didn't admonish him of affirmative defenses? I mean, I'm not sure I've heard that. I've heard very conflicting testimony from both Miss Lee and Mr. Campbell in how their meeting and their conversations went down at the jail and office. And Mr. Campbell says that he doesn't recall going to the meeting with her at the office, but can't say it didn't happen, doesn't feel comfortable in testifying to that. Yet she's testified that they sat in her office, not in the jail, not when he's in custody, not when he's expressed through his testimony a desire to get out of jail, which she has also corroborated as being his statement. What do you believe has been borne out by the testimony that's not speculation as to what could have happened later, but what did happen at the time that he did stand before the court, he did enter his plea? As counsel's aware, I painstakingly, I don't do a fast plea. I don't line up 10 people and go through. I spend the time that it takes for each individual to make sure that the person understands what they're doing, that they're doing it intentionally, knowingly, freely, voluntarily, that they're competent, that they're pleased with their attorneys, that they've had enough time, that they have any questions, that they understand everything. And I have no doubt that I did that for Mr. Campbell, as is my practice. And Mr. Campbell raises nothing on that day, has no questions for the court, goes on probation, says nothing throughout his whole term of probation. And it's not until he's rearrested on a violation that any of this is brought to anyone's attention. How is the court to take what's in the testimony today and reconcile that with those procedural due process safeguards that the court goes through with each and every defendant, including Mr. Campbell? That's a lot.
Trying to figure out where the question is.
What, and I'll restate, what do you believe that is borne out by the testimony of Miss Lee and Mr. Campbell today that's not speculative?
I think cumulatively what you get is an attorney presenting a plea offer for the first time to a defendant in custody. I think you also get through the testimony of Mr. Campbell and the lack of recollection from Ms. Lee that she basically, I guess the word I'm looking for is told him that his self-defense claims were not allowed. Now you can draw inferences from that testimony, but the inference I would draw is that she knew that if he didn't get him to take the offer, she would have to go to trial. And I think her testimony also showed us that she hadn't been to trial before. And it's a serious felony offer. So had she taken the time to review and look into the actual self-defense claims, and furthermore, here's the other thing, that one of the things that she had said was that she didn't go over one time in her recollection of the discovery. You're setting up for a trial on a second or first degree felony offense. Spending quite a bit of time going over that before you're ready to announce that you're ready for trial, much less go to trial. So under the circumstances, I can tell you that in my practice, if my client told me they weren't guilty, I wouldn't allow them to. I wouldn't do it, because then they'd have to get up in front of the court and say something that I didn't think would be true. And ultimately I would be sworn further testimony. I don't think that was the case here. And I think that Ms. Lee and Ms. Campbell, Mr. Campbell both testified that he maintained his innocence throughout their relationship. And it wasn't until the last day of that relationship, procedurally, whatever happened before that, that he took a plea. Now, she said she didn't want him to take a plea. Probably not. You believe it or not, I'm not going to have an obvious way, but I'll just tell you that at that point, if my client had told me I'm not guilty of this, then I'm not going to enter a plea on his behalf. That too is a big problem. And so
Well, and let me ask another question. Mr. Campbell and Miss Lee both testified to the fact that Mr. Campbell asserted his desire of he wanted to be out of jail that day. And looking at the record, Miss Lee had filed a writ of habeas corpus, and that was set before the court to consider reducing his bail or granting him some kind of personal bond or personal recognizance bond. Wasn't set for any typical court hearing, no arraignment, at that date, wasn't set for arraignment that day, pre-trial docket call, anything of that nature where the court would be expecting the defense or the state to express some kind of disposition. It's difficult for the court not to believe that where I have conflicting testimony on other issues, that testimony is the same that Mr. Campbell wanted out of jail that day, and on that day stood before the court and didn't assert. And we've talked about innocent versus not guilty versus justification. So there's not a claim of actual innocence here, is there? There's a claim of, there's an affirmative defense that was not
Correct.
brought to the court.
I think that.
Okay.
Correct.
So that's hard for the court to reconcile, along with the fact that Mr. Campbell has sat on that information after being put on probation for a significant amount of time without ever bringing that to anyone's attention, probation officer, anybody. There's the record's void of any evidence that suggests that.
Right, Judge, and I understand it's more, it would be great. You know, when you have an indigent defendant who receives court appointed counsel on both the underlying offense as well as the motion to adjudicate, that individual doesn't have the funds to hire and train, nor would they have the ability to seek redress after the fact. It wouldn't be abnormal at all in my mind for an individual who's on probation not to say anything. What would they say? And furthermore, if they did say something for it to be on the record, they would have to have some file with the court. They didn't have the funds to do that, nor would the court appoint an attorney to represent an individual on a desire to file a writ or a motion. So I understand that now.
No, and let me say, I understand that as well, but what I don't hear today is a probation officer testifying that he's maintained his innocence from the very first time he processed in. And that's something that this court has heard before. That's really what I thought I'd be hearing today, is someone else saying that he's maintained his innocence all along. But I've only heard that from Mr. Campbell today, and his testimony is conflicting with that of Miss Lee's.
And Judge, I agree with Mr. Crawford over here in a minute to provide additional testimony along those lines.
Does he have that testimony? Mr. Crawford, does Mr. Crawford have that testimony?
Charles?
Or whoever the probation officer is?
My client has told me that they have this. Now,
Well, I'd be interested to hear that.
yes, sir.
I mean, I think what you are asking the court to do is to take Mr. Campbell's word for it. And it's conflicting with what Ms. Lee said today, and it's more speculative about what was going to happen if he didn't take the plea versus focusing on what happened at the time of the plea. And the only thing that I know that happened at the time of the plea is that Ms. Lee says he wanted out of jail. She said he wanted out of jail. And Ms. Lee says that she's not in the practice of pleading out her people if they're not guilty, and if they're saying that they don't want to plead guilty, but that he asserted he wanted out of jail. And at a writ hearing, he pled out and stood before the court and said he was guilty, brought up nothing to me or anyone else about these alleged offenses or not being guilty. And I even asked him in my plea, are you not pleading guilty for any other reason other than you're guilty? So I'm just saying, and I think you referenced it, it's a high threshold. It's a very high. And I'm saying right now, I don't see the evidence to get Mr. Campbell over that. Now, Mr. Crawford sits in here and says, oh yeah, we've had a lot of, discussions over this that may affect the court's opinion.
Judge, in that case. Yeah, if we could reopen. I can see if I can get a hold of Mr. Crawford, see if he's available at the moment to testify.
Okay, we can do that. We can recall the case.
We recess and Mr. Campbell's case, I'll just see if I can answer it now.
Ms. Heisel, do you have anything else that you want to add? I'm assuming that the state's still in agreement with this.
Yes, Your Honor, I don't think there's anything I want to add to this.
Okay, and after Mr. Crawford testifies, I may have some more questions about the stipulation of evidence that we talked about in chambers on first aggressor, affirmative defenses, and those things.
And Judge, I think that, on the record, one of the things that I would argue, agree to that is that if our claims are valid, which I believe would be honest, there would not have been a stipulation of evidence for the court to look at. And if this matter proceeded to trial, there would have been a transcript and evidence admitted. So what I understand the court references is what was submitted at a plea. And we're claiming that plea was invalid or should be found invalid to start with. So I understand that's all we have to go on unless we get that picture here on the underlying facts of the actual case. We haven't breached and most likely won't. But I just want to make sure the court is aware that you don't stipulate the evidence if you're going to trial, which is generally done.
Sure.
So,
But I think y'all maybe overlook the other procedural safeguard that is required in felony pleas that's not required in other pleas. And that is that the felony plea has to be supported by evidence, reviewed by the court, and determined to be sufficient before a person could be convicted on it. Mr. Campbell could stand up and say he's guilty, and I can review the evidence. And if I don't find sufficient evidence to convict him, I can't allow him, just like you say, you can't allow him to plead guilty. The court cannot accept his plea of guilty. And that has happened in this court with this DA's office. I have reviewed it and said, I do not see the evidence here to substantiate his guilt. Therefore, I'm not accepting it. And so to say that the court shouldn't be able to go back and look at the stipulation of evidence really guts the court to be able to say that it followed the due process procedural safeguards in making sure that there was sufficient evidence to accept his plea at all. So I understand your argument that, which I think is speculative. If she would have been a better lawyer, she wouldn't have pled him, and then there wouldn't be a stipulation of evidence. But the fact of the matter is, he did plead guilty. The court did review the evidence. I did find sufficient evidence. And within that evidence is the alleged affirmative defense of self-defense. And so the question I'm going to have is laid out in that states one. We can take that and we can analyze whether or not Ms. Lee appropriately or inappropriately assessed the value of a defense. And the court's first reading of it would indicate that Mr. Campbell would not be entitled to a self-defense claim. Granted, I didn't spend time talking with Mr. Campbell. I've read, a hearsay statement from a police officer who's recorded that from other witnesses. So that's going to be something that I think we're going to have to overcome as well. As far as touching on the speculative part of whether Ms. Lee should have been appointed to the case or not. So we can put a pin in that. Let's recall it. We'll get Officer Crawford over here and see if he can enlighten the court on anything on the other issue.
And I think also, I still have a couple other police defendants that have the project.
Let's see. I think we were only bringing these 6, and then what we were going to do is let you go back over there to handle that. I anticipated that we'd finish up these 6 and then allow you and Mr. Manning to go back over there, so we didn't bring everybody over here. If we have transport staff available and we can take some of these back and bring them, I'm fine with that. I'm not sure what the jail staff had planned for that.
We should already all be full. Such a deal about longer.
I sure do. Cool.
I got everyone on the very good shit.
they're just gonna come over now.
Yeah, that's what I'm seeking.
So we're done with 1, 2, 3. What's your name, sir?
Oh,
Coleman. We've already done a Coleman. That's your agreed.
yes.
Right on. Okay, so
I don't know the other people last back, but everybody else.
that's Mr. Ragland. That's Mr. Ragland.
We should be done with like this.
Do you want us to bring some over?
Yeah. Maybe, and that's what we did. I mean, if it's in the trouble, I don't see all the rest of it.
Yeah, what we had planned on doing was just the ones that we knew we needed hearings on. We were gonna bring them over.
Heiser and texted me asking me if we want if we could take the other ones back. I said, well, each last one we can take
Take the other ones back.
the other 4 prisoners. This was when y'all first started with them. I didn't think it would take that long.
All right, Mr. Manning, are you ready?
Yes, Judge.
Who are you ready on first?
Ready on plea from Miss Jeanette Platt.
All right, this is cause number CR 0834 CR 0835, State versus Jeanette Kelly Platt. And is this a plea today on motion to revoke?
Yes, Judge, we're going to proceed, our state's proceeding on CR 0834 and withdrawing and terminating on CR 0835.
All right, and what are the terms on the plea?
Judge, she has a 2nd-degree felony. She's going to plead true to that. To the motion to adjudicate, her guilt be adjudicated. Supervision revoked, punishment assessed at 3 years, the balance of financials. The fines show to be $2,000, restitution, the amount of $140, court costs, the amount of $351. And she has a total jail time credit of 253 days credit. Judge, additionally, my client, when I arrived today, my client asked me about the possibility of paroling here out of Van Zandt County. I told her that that's not up to myself, the state, or the court, but she asked if that would be a possibility in her case.
Okay, and I think you have admonished her correctly that it's going to be the decision of the Texas Board of Pardon and Paroles and TDCJ on whether or not she's picked up or whether or not she completes her sentence here in the county, or if they pick her up and process her into a prison. All right, I'm trying to display this motion to revoke. All right, Ms. Platt, it appears that you appeared before the court on August 5th of 2010. You pled guilty to the offense of possession of a controlled substance in penalty group 1 between 4 grams to 200 grams, a 2nd-degree felony. Court heard the evidence, found that there was sufficient evidence to convict you of the offense. However, the court followed a plea agreement that you reached with the state. The court deferred a finding of guilt and placed you on community supervision for a period of 8 years and ordered you to pay a $2,000 fine. It was during this term of your community supervision that the state has filed this motion to adjudicate and revoke your community supervision. And as I am showing you here, the state has alleged in 9 separate counts of various ways that you have violated your community supervision. Have you had sufficient time to review this with your attorney, Mr. Manning?
Yeah.
All right. And Ms. Platt, let me go ahead and swear you in before I forget to do that. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
All right, thank you. And so, Ms. Platt, you've told me that you do believe you've had enough time to review this motion with your attorney, Mr. Manning.
Yes.
And do you have any questions about the motion or any of the paperwork that you've read over and signed today?
No.
And are you pleased with Mr. Manning's representation of you?
Yes.
Okay. Mr. Manning, does your client waive the formal reading of the state's motion to adjudicate?
We do, Judge.
And does she intend to plead true to all 9 counts?
She does.
All right. And do you believe that she's competent today and is entering her plea before the court intentionally, knowingly, and voluntarily?
I do, Judge. She did have some questions about the original underlying charge, as it was so long ago. I was able to get the original judgment and show her certain things that answer the questions. And so throughout this time she's interacted, she's had questions about possible defenses and or negotiations throughout this process.
All right, thank you, Mr. Manning. All right, Ms. Platt, I'm going to ask you at this time, I'm showing you this motion to adjudicate and revoke as to counts 1 and 2 on page 1, and then 3, 4, 5, 6, 7, 8, and finally count 9. Are those counts true or not true?
True.
Are you telling me that each one of those counts is true because in fact, what is alleged is true? You're not just saying that to get a certain plea agreement or get out of jail today? No? Has anybody threatened you, forced you, or pressured you, otherwise made you feel like you had to plead guilty? Or I'm sorry, had to plead true to any of these allegations?
No.
All right. Court will accept the defendant's pleas of true to each count alleged in the motion. Mr. Manning, any objection to the defendant's waiver of rights and plea of true?
No objection to states 1.
All right. Court will admit, I'm going to admit it as State's Exhibit A. And the court will take judicial notice of the defendant's judicial confession. Anything further from the state? Okay. Anything further from the defense, Mr. Manning?
Nothing from defense, Judge.
All right, then Ms. Platt, based on the evidence before the court and your judicial confession, the court will find that you have violated the terms and conditions of your community supervision. The court will follow the plea agreement that you've reached with the state. The court hereby convicts you of the 2nd-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams less than 200 grams. Court will revoke your community supervision and assess your sentence at 3 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will also order you to pay the balance of your financial obligations. Mr. Manning, any jail time credit that she's receiving?
Yes, Judge, 253 days.
Ms. Platt, the court awards you 253 days credit towards your sentence for the time that you spent in jail on this cause. And Ms. Platt, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I will have someone there at the jail take your fingerprint, and good luck to you.
Thank you.
Mr. Manning, I'm going to bring in the Henderson County Jail real quick, if you don't mind.
Not a problem, Judge.
Thank you. Good afternoon, Mr. Weiner.
Afternoon, Your Honor.
All right, I think the Henderson County Jail is getting logged in.
Good. You can hear them, they can hear you.
I believe so.
Good afternoon, Mr. Rhodes. How are you?
I'm all right, Your Honor.
All right, this is cause number CR 2249, State of Texas versus Dusty Lynn Rhodes. Mr. Rhodes, can you see Mr. Weiner on your screen?
Yes, Your Honor, I can.
Excellent. Okay. All right. And I show that Mr. Rhodes is set for pre-trials, what I have on my docket, and there may be another, is there a motion also before the court to reduce bail or something of that nature?
There is, Judge.
All right, let's take the pre-trial first. Are there any issues on pre-trial?
Your Honor, not that I'm aware of. I do want to talk to the state about a couple of minor issues. This is my first appearance on the case. I subbed in for another lawyer. I'd like to have one additional pre-trial setting. If not, I'd like to ask the court for leave to file any necessary pre-trial motions. I don't anticipate there are going to be any, but I don't want to be at docket call and you asking me why I didn't do this at pre-trial. So
I appreciate that. All right, the court will grant you leave to file any pretrial motions as you see that are necessary. So we'll go ahead and set this for docket call, and then we'll take up the motion to reduce bond or bail.
Thank you.
Let's see, and you got your calendar, Mr. Weiner?
Pulling up right now. Yes, sir.
Do you have any proposed dates? You know, when you're coming back, I would be looking to set probably maybe December 1st. I think November 8th and 10th would be pretty quick. However, if you want something that early, we can do that.
December 1st will work, although I am likely, if it's okay with the court, I'm likely to be late. I've got a plea in the 392nd at 1:30 that I need to get. I have a client that flies in from Oregon, and so I need to get her squared away. So as long as you're okay with me appearing a little late or even Zooming, I guess.
That should be fine.
Okay, great. I'll put it.
Either should be fine. So, all right. So Mr. Rose will set you for docket call on December 1st. That'll be at 1:30, and knowing that Mr. Weiner may be a little bit late. I'm going to write that down, Mr. Weiner, so I don't ask Ms. Taberham, where is Mr. Weiner at?
Sure.
Because I've done that, unfortunately. And I had to go back and look at my notes. I'm like, oh yeah, he told me.
Yeah. It's good to be busy.
It's good to be busy. All right, and Mr. Woodwike, are you going to be handling the motion to reduce bail?
Yes, Your Honor.
All right, go ahead, Mr. Weiner.
Your Honor, the only witness I have is my client. I'd call Dusty Rhodes for the limited purposes of discussing his ability to make bail.
All right, Mr. Rhodes, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor, I do.
All right, thank you. Just continue to speak up loudly and clearly. Go ahead, Mr. Weiner.
All right, Dusty, just be sure and only answer the questions that you're asked, okay?
Yes, sir.
All right, please state your name for the record.
Dusty Lynn Rhodes.
And you're currently incarcerated in Henderson County Jail, but there's a hold out of Van Zandt County. Is that right?
Yes, sir.
And you've got a pending evading arrest charge. Is that right?
Yes, sir.
And what is your bond set on that?
No, I'm on bond for that. I'm on bond for that. The bond that I have right now is a state jail felony that it was a 10-year-old charge from 10 years ago.
Okay.
That just popped back up.
Okay. And what is the bond on that?
It's 40,000.
Okay. And that's for a state jail felony?
Yes, Your Honor.
And
Yeah,
you
I'm
were,
sorry.
it's okay. Don't worry. I know you're nervous. And so you actually had been in jail on that state jail felony like almost 10 years ago. Is that right?
Yes, sir.
And you actually worked out some business in another county and went to TDC. Is that correct?
Well, I was in Van Zandt County for over 90 days. They didn't indict me, so they gave me a PR bond, and then I went to another county and went to TDC.
Okay, got it. If you were able to make bail on this charge, where would you live?
I would live with my sister and my mother in Maybank, Texas.
Okay, and your sister and mother, how long they lived there?
22 years.
Okay, and if you were to be released, what would you do for work?
I already have two job opportunities. The one job is with Citywide Construction where I worked previously. And then I have an opportunity to go to West Texas on a not fracking, but water transfer for the fracking company. But I didn't know if that would be okay. So
But you've got options though, right?
Oh, yeah. Yes.
And you have a vehicle?
Yes, I do.
Do you own it outright?
Yes.
Okay, so you have an ability to get to and from court as well.
Yes.
And you understand that the court could put numerous conditions on you as conditions of bond. Are you willing to abide by any and all conditions for the court?
Yes, sir.
Okay. As far as trying to make this bond, have you tried to make it?
Yes, several times.
Okay. And while you're incarcerated, it's very difficult for you to get your funds to the right people so that you can make bail. Is that correct?
Yes.
If you were to put all the money that you have in bank accounts, checking accounts, retirement, if you've got it, how much money would you have?
At this time, I would have about $1,400.
Okay, and that's all you have to your name, is that right? Other than this,
Yeah, that's all I have to my name, and I've got 2 other bonds to go with it. So
okay, the vehicle though that you own, what kind of vehicle is it?
it's a 2008 Infinity.
Okay, how much do you think it'd be worth realistically if you tried to sell it?
I think it would be worth. I paid 7,400 for it a year ago, a little over a year ago. Since then, my sister she wrecked it. The front clip, it's got a little bit of damage in the front. I would say realistically, without having to wait, just to get the money right away, probably 3,500, 4,000.
Okay, it's also very difficult for you to arrange to sell that vehicle while you're incarcerated. Is that correct?
Yes, my mother's bedridden. She's fully disabled. My sister works full time and takes care of my mother. I was my mother's primary caretaker, and now she don't have long to live, and she has regressed significantly. She has blood clots in her arm. She they don't expect but she's the main thing is she's being neglected. I was the only one that had the time to take care of her. My sister doesn't necessarily have the time and isn't as concerned about it. Sorry to say. So my mother's just kind of being neglected.
And so that's one of the reasons that you want to make this bail so you can be with your mother and kind of in her final stages of life. Is that correct?
Yes, sir.
Yeah, I'll pass the witness, Judge.
Yeah, Mr. Weiner, before we allow Mr. Woodwhite to ask any questions, let me get some clarification. So this motion to reduce bail it's not in the case that's on the docket today. It's in CR 1326. Is that right?
Judge, I don't have that file right in front of you. That does sound right, though.
Okay.
Judge, based on my records, that is correct. It shows on my docket, but I don't know why. I have both cases on my docket. One is shown for pretrial, and the state jail from CR 13026 shows to be a state jail. I believe that's what we're talking about. That's what the motion was filed into.
Okay. And the original bail was $20,000 in that case, in the CR 1326. Correct?
Yes, Your Honor.
Okay, and that appears, and I'm looking through my clerk's record, and that appears to have a judgment Nassau on forfeiture of bond on or about March 21st of 2013. The capias issued subsequently to that. And then it appears that there was another order declaring, let me look at this. So Mr. Rhodes he posted the 20,000, and then there was another bailiff certificate on or about May of this year. And that's how we got to the 40, correct?
That is correct. And if I can verify, he may have actually been in a different jail.
Yeah, and I think that's kind of where I'm going. So on May 17th, I signed an order declaring a bail forfeiture, which I presume was the 20,000 that he posted. That was in May 17th of 22. Then I show that the order declaring bail forfeiture. Let's see, there's a recall of the capias in July of 22. And the capias was returned unexecuted. I guess what the point I'm getting at is I think that Mr. Rhodes is still on a $10,000 bail in this case. And because I show that the capias was recalled. Let's see, it says order of recall of capias requested by district clerk. Date of recall, July 14th, 2022 by the clerk. tell you what I'm gonna do, Mr. Weiner, you can help me out here. All right, can you see that?
Yes, Your Honor, I can.
All right, so if we go down here, we'll see there May 17th of 22, there's an order declaring bail forfeiture. That's where bail was set at 40,000 by me.
Right.
So there's an alias KPS, and then there was an order of recall. It says order of recall of KPS from March 22nd of 2013. So that was recalled. I'm just kind of confused by what I'm seeing here.
Oh, I understand why, Judge. That doesn't make a whole lot of sense.
Let's look at this one here. Looks like it's recalling the KPS from March 22nd of 13. I'm not sure why. March of 13. All right, I'll see if I can figure that out. So I'm sorry, Mr. Weiner. Go ahead. Or I'm sorry, Mr. Weiner, pass the witness. Mr. Woodwike, any questions?
Just briefly, maybe we could get Mr. Rhodes to shed some light on some of this. Mr. Rhodes, in your testimony, when your attorney asked you, he said that you had in between basically the time that you had appeared last in this court on the state jail charge, and this time you were in custody in another jurisdiction. Were you in custody March 21st of 2013? Are you aware? I know that's a number of years ago, but do you remember that?
To my recollection, when I got the PR bond, I had another misdemeanor that I bonded on, and then a felony hold out of Dallas County, and Dallas County picked me up in February from the jail. And then in 2014, I was still in Dallas County and was sentenced to TDC. And when I got to TDC, the hold for Van Zandt County popped back up. And then I was released in 2015. And the day I was released, the hold went away. I never heard anything else. And then actually went back to TDC one more time and never heard anything. And then I came home. I did 5 years and come home. And this is the first, I completely forgot about this charge. I thought maybe it was dismissed or I just wasn't sure. I wasn't sure. So when they showed up at my door in May or June and said, "Hey, you got a warrant for your arrest down in Van Zandt County," I was like, whoa, you know what I mean? I had forgot about this charge completely. So to my recollection, yes, I should have been incarcerated because I was never released.
Judge, I have no further questions.
And thank you, Mr. Woodwike. I think that probably does help. I think that there may have been an understanding or a realization that Mr. Rhodes was in custody and they recalled the 2013 KPS, and then the case was set in May when he was released from TDC, and that's where the new order declaring bail forfeiture was entered, setting the 40,000. So I think that probably does, at least in my mind, shores that up a little bit. So any other witnesses, Mr. Weiner?
No, Your Honor.
All right, you want argument?
Yes, Your Honor, briefly.
Go ahead.
Your Honor, it's a state jail felony, realistically, and I'm still a little confused with all the holds and release of the holds, that sort of thing, but I'd like to investigate a little more. I mean, it looks like there may be an opportunity for him to even have time served on this potentially, since he might have had a hold or should have maybe had a hold while he was in TDC. And so, Judge, I just ask that you lower the bond to an amount that you feel like is reasonable so that he can post bail, continue coming to court and take care of his dying mother.
All right, thank you. Mr. Woodwike, anything for the state?
Judge, Mr. Rhodes appears to be on bond on the newer charge. Given the confusion, given his custody status 8 years ago, state would not be opposed to the court lowering his bond to something that the court feels is sufficient to ensure his appearance at court. Mr. Weiner and I am sure will be able to reach some agreement as to this charge at minimum. And we will be able to proceed on his other more serious charge, which he is currently on bond or is not before the court for a bond reduction at this moment. So the state is comfortable with whatever the court wants to do on this charge.
Okay. And what is Mr. Rhodes' current bail on his CR 22-249? It's an evading. You know what his bail is on that?
Dusty, what's your bond on the evading charge?
10,000.
Okay,
Okay.
I posted that last year, $10,000 bond.
thank you,
Okay.
Dusty.
All right, the court will grant the motion to reduce bail. The court will set Mr. Rhodes bail and CR 1326 at $10,000 cash or surety.
Thank you very much, Judge. I appreciate the state.
Hey, you're welcome. All right, anything further, Mr. Weiner? And we'll go ahead and we'll set both cases for that 12-1 docket call day
That I might be late on.
that you probably won't be late on.
All right, thank you very much, Judge. Dusty, give me a call in my office when you get back to your pod, okay?
Yes, sir. Thank you.
And that's all I have, maybe excused.
Yes, thank you, Mr. Weiner. Mr. Rhodes, tell Henderson County staff, I apologize for the delay and appreciate their help.
Yes, sir. Thank you. Thank you, Your Honor.
You're welcome.
Nothing easy today, huh, Judge?
Not today.
Okay, all right. Y'all have a good one.
See ya. All right, let's see. Mr. Manning, are you there?
Yes, Judge.
All right, you ready to proceed?
Yes, Judge. I'm unsure as to which one the state wants to proceed, but I have both Ms. Fleming and Ms. Lopez Ramirez here.
All right, bring Ms. Lopez up. WR 2294, State of Texas versus Kirsten Lopez Ramirez. And are you going to be calling Ms. Ramirez today?
Judge,
Lopez.
before we begin, I had made a proposal to the state in regards to make possible agreement on Mr. Ramirez's bond. Mr. Woodwike said he was gonna take a look at something real quick and then was gonna make an announcement.
Yes, Judge, and I was in the process of trying to text Mr. Manning when we moved on to something else that, but we have reached an agreement based on what Mr. Manning proposes that Ms. Lopez Ramirez can make. We would agree for PR bonds on all charges except for a $10,000 cash or surety. I'm trying to get the cause number. It's one of the second-degree charges. But court will allow me just a moment. Judge, if the court would set it on the it's DA control number 2022-0996.
Yeah, unfortunately, my order doesn't have that.
It's possession of controlled substance, penalty group 2, between 4 and 400 grams.
Which one is that?
It's the very top one, Judge. We'd set the top one at $10,000 cash or surety. State would not be opposed to setting the rest and remainder at, I believe they're all, Mr. Manning's order appeared to say 10,000 personal, or if the court wants to set them at personal, that would be whatever the court would prefer to do on that.
Is that the agreement, Mr. Manning?
Yes, Judge.
All right, so the court is setting $10,000 bail cash or surety on the first charge referenced on this writ, possession controlled substance penalty group 2 between 4 grams and 200 grams. Court will set $10,000 cash bond on the remaining
Judge, $10,000 personal bond.
personal bond, except for the possession of marijuana. The court will set that at 1,500.
That is more than sufficient for the state, Your Honor.
All right, Mr. Manning, I'm going to get that signed and we'll get that filed.
Yes, Judge. And we will, once Ms. Lopez gets that, Judge, she believes that she will be able to make that. If not, I'd ask if the court would be willing to reconsider the writ on that remaining $10,000 when the 9 days is up, which I show is going to be in approximately 2 weeks.
Yes, court will reconsider upon request. Did you say, is this Hensley?
Ms. Fleming?
Fleming, oh. CR 21-261 State versus Laura Joy Fleming. Go ahead, Mr. Manning.
Judge, I'd like to call my client.
Ms. Fleming, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
All right. You can lower your hand. You're going to have to speak up louder than that, or I'm not going to be able to give you anything that you want today. Okay.
Yes, sir.
All right. Go ahead.
Ms. Fleming, can you state your name for the record?
Laura Joy Fleming,
And how long have you been in Van Zandt County Jail?
almost 90 days as of next week.
And during that time, you switched attorneys, is that correct?
Yes,
Okay.
sir.
And you were put in jail for violation of your bond. What was that?
I had a dirty urinalysis.
Okay. And did you admit to that?
Yes, sir.
Okay. And prior to that, you'd been on bond, is that correct?
Yes, sir.
And how long had you been on bond?
Over a year.
Okay. And during that time, had you ever missed a court date?
No, I was a day late this last time.
But beyond this
No.
last time when you got put in jail, you've never been late before. You never had any bond jumping charges, never had any evading arrests. You've never had any bond forfeitures on you whatsoever. Is that correct?
Yes.
Your bond was set at $300,000 when I first became your attorney, is that correct?
Yes.
And sometime in between when I filed the writ, it is your belief that that bond was reduced to half that amount, which is $150,000. Is
Yes,
that
sir.
correct? Can you make a $150,000 bond?
No, sir.
Okay. Do you have a home?
I live in an RV in my mom's.
Okay.
on my mom's
But
property.
you don't own
No, I
any
don't.
property?
No, I own a car.
You don't own a house. You don't own the RV that you live in, is that correct? Do you have any bank accounts?
No.
Okay. Do you have any other assets that you could use to raise a bond besides your vehicle?
No.
Okay. And what vehicle do you own?
I own a 2004 Mitsubishi Galant.
Okay, and approximately how much would you believe that be worth?
I bought it for $1,900. So $1,800.
And
Mr. Manning, I'm having a real hard time hearing her.
I'm sorry. 1,800 is what it's worth.
that was a 2004 Mitsubishi Galant, Judge.
Okay.
And if you were released on a reduced bond or a PR bond, you would be able to continue appearing in court as you would,
Yes, sir.
and as you have previously.
Yes, sir.
Would you be able to get away from the environment situation you were when you ran into trouble last time?
Yes, sir.
Okay.
Yes.
And is there some type of bond that you could make if the judge would reduce it from $150,000?
Yes, sir.
And what would that be?
30,000.
And what type of charge are you here on?
Then
Okay.
that
And what level theft? Is it state jail?
state jail.
Okay.
felony.
And that state jail felony was enhanced due to previous convictions for theft. Is that correct?
Yes, sir.
But you've been in here over 3 months, awaiting trial and awaiting your day in court. Is that correct?
Yes, sir.
And it's true that you've actually provided, your attorney's provided an affidavit that is currently being investigated by the DA's office that would possibly provide a defense to these charges.
Yes, yes, sir.
Is that correct?
Yes, sir.
And would you be able to assist in your defense better if you were on the outside assisting and helping?
Absolutely.
Okay.
Yes, sir.
You are not pass the witness.
Mr. Woodwhite,
Your Honor, I'm sorry, this is mine. Can we assure that the jail can hear me?
you may have to come up here because it goes through here, not through there.
Thank you, Judge. Ms. Fleming, did I hear your testimony correctly that you said that you have never failed to appear for court before?
I was a day late before.
Okay, so if the court had records that you failed to appear for court on August 1st of this year, that would be correct.
Yes, sir. Yes, ma'am. I'm sorry.
And additionally, you have previously appeared and provided a dirty UA to the Community Supervision Department. Is that correct?
Yes.
Honor, I'd pass the witness.
Mr. Manning, any additional questions?
Nothing for this witness, Judge.
Any additional witnesses or evidence?
Judge, no additional evidence. I just have asked for a short argument.
Okay, any evidence or witnesses from the state?
No, Your Honor.
All right, go ahead, Mr. Manning.
Judge, she's been in here for 9 months on the state jail for a dirty UA and for being a day late. Judge, she's never missed a day of court besides that last one where she did have the dirty UA. We'd ask that her bond be reduced to a reasonable amount for a state jail offense so that she can continue wait for her day in court instead of being in here in jail, being held at a bond that is currently set in a manner that is overly oppressive.
Thank you, Mr. Manning. Ms. Heisel.
Your Honor, Ms. Fleming's bond was set at $300,000 on the day that she failed to appear back in August. We have already agreed to reduce that down to $150,000. I think given her record showing that she does have an inability to show up when she's scheduled, and furthermore, her inability or unwillingness to comply with pretrial release conditions by not consuming illegal substances, state would ask that you hold her bond where it is.
Thank you, Ms. Heisel. All right, based on the evidence, the court's going to deny the application and motion to reduce bail for Ms. Fleming, and the court will continue the bail as it's currently set. Is it currently set at 300 or is there an agreement at 150?
I believe it previously been reduced to 150, Your Honor.
So I think it's still showing 300. If it's not been previously reduced, then the court will set bail at 150.
Yes, Judge.
Mr. Manning, are you ready on any others at this time?
Judge, that's all the inmates that are currently in here. They're going to get
Okay.
the rest of mine.
Okay, we'll take up some other pleas. Mr. Schmidt, are you ready for your pleas?
I am. I'm going to take this family again, so the probation officers, it's up to the court. They're sitting right.
That's fine. All right, court's going to go back on the record with Mr. Campbell. Mr. Campbell, you can come back up there and have a seat with Mr. Schmidt. Court's going to allow the defendant to reopen on the motion to revoke, motion to withdraw guilty plea. Mr. Crawford, you'll come forward. To our makeshift witness stand over here. You'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Thank you. Please have a seat. Just make sure that we speak one at a time. Go ahead, Mr. Schmidt.
Station agent registered,
Charlotte Crawford.
and this Crawford, you're a Madison County probation officer, I think.
Yes.
And were you a probation officer in 2019 here in this county?
Yes,
And do you call supervising Robert Baker King?
I do.
And that's anything you right now.
Yes, sir.
Just briefly, after you began supervising him, do you recall how long you supervised?
Maybe 3 months. It wasn't very long.
And during that time, did Mr. Campbell assert his innocence to you in your office in that time?
Yes.
Not in so many words, but did he claim to you that he was acting in self-defense?
I think it's false.
And normally, in your role at the probation department, once they get to you, it's not your business to discuss or do anything about, whether or not they claim innocence, is that correct?
Yes, that's right. I spoke with him, kind of just push forward on time and continue probation.
And normally, what would you do with your advice to the defendant to contact his lawyer under those circumstances and continue to supervise?
Yes.
That's
No questions.
Mr. Crawford, did Mr. Campbell comment to you that his lawyer forced him into taking a plea, or that he was made to enter a plea he didn't want to enter?
I don't recall that. I do recall a story about potentially defense and style of law being pressured.
What do you call specifically about potential self-defense?
Like the story of what he told me what happened.
Yes.
Yes, he told me, it's female, I guess coming down the street, he was out in the street to stop a female. Or they were having issues and was, coming at him with the truck. And he had a shotgun, and so he said he shot the shotgun into the front of the truck, and hoping that she could stop. And I just said, down the way. That's the route of all these stories.
Thank you. I have no further questions.
This car, do you recall when I told you that when you shot at a vehicle in the radio that what he was aiming at the passengers, or do you recall that? Do you recall he told you that he was pinned up against the fence when he fired?
I don't recall that. I recall as the electrician. He had mentioned that they noticed the vehicle was coming over the hill with the high rate speed. But I don't recall.
So Mr. Baker, I'm sorry, Baker, Mr. Campbell told you that he was aware of witnesses that viewed it and what their statements were?
Yes.
My recollection that he said he didn't know about the witnesses or had never gone over that discovery with.
With the sleeve, that's correct.
Yeah, okay.
I believe judge's testimony was that we exposed other individuals who were aware of this.
Okay. All right. I don't have any further questions from the court.
Thank you.
Thank you, Mr. Crawford. You can go. Y'all need Mr. Crawford for anything else? Thank you, Mr. Crawford.
Thank you.
Carolyn Bryant.
Ms. Bryant, you'll come forward. Ms. Bryant, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth? So help you God.
Yes, sir.
Please have a seat. Go ahead, Mr. Smith.
Thank you, what's your name for the record?
Carolyn Bryant.
And you with the Madison County Probation Department.
Yes.
And, have you had an opportunity to supervise or work with Robert Campbell?
Yes.
And that's him, people in here, that you do recognize him?
Yes.
During your supervision of him, did you, discuss with him the facts of the underlying case that he was on probation for?
Not so much the facts of it, but he did tell me that, it was a bogus charge.
Did he tell you that he acted in self-defense?
Yes.
And did he ever, speak to you about his attorney on that plea, misleading, year of running conversation, and when Mr. Cameron, excuse me, stated to you that he should not play guilty and that he wanted to get this. What was your response to him on those circumstances?
That this wasn't the time to address that, because that should have been figured out before you pled for probation. And I didn't start supervising him until March of 20, and so he had already been on probation for several months, and it was just time to move forward and do what we needed to do to get this behind us.
State.
Just briefly, so Ms. Bryant, prior to you supervising Mr. Campbell, was he on Mr. Crawford's caseload?
Yes,
And was he ever on anybody else's caseload previous to Mr. Crawford?
not to my knowledge.
Okay, so he came straight into Dartmouth and then. And even though it was several months later, he was still asserting that he was not guilty and that he had helped.
Yes.
Your Honor, absolutely.
A question from the court. Is Mr. Campbell the only person that's told you that he's on probation for a bogus charge?
No,
Well,
this is something that a lot of people say. And so my natural response, and especially in March, just being new, this should be determined before you get here. When you get here, we're carrying out probation term.
so you weren't overly concerned when Mr. Campbell told you that, because you're telling the court that you've heard this on other occasions from other individuals.
Correct.
Would you say that's commonplace or not common?
It is common for people to say that.
All right, thank you. Any other questions from council? All right, thank you, Ms. Bryant. You can step down. Any desire to keep Ms. Bryant?
Oh, no, thank
Yes, ma'am. Thank you, Ms. Bryant. Thank you, Mr. Crawford. Appreciate it. All right, so let's go ahead and I think we were in the middle of closing argument last time. Start over if you want, whatever you want to do, Mr. Schmidt.
Good, no, I think, I mean, at the end of the day, Ash for a lot of the testimony. I think that we presented enough to the court at this point that, but for ineffective assistance, the plea would not have been entered. In addition to that, I think that, hearing what we've heard pertaining to defenses, ultimately combined with the ineffective assistance, I argue that the plea was not knowingly entered. I also think that under the perfect standard, the pressure that you received on the day of the plea, take the plea, or sit in jail for another year, obviously, as a court is aware, that is a motivating factor for anyone to enter a plea. But an individual who maintains innocence with his lawyer, an individual who asked her to look into the self-defense claims, and depending on whose testimony is relied upon, ultimately was strong armed in taking a plea that he believed that he didn't take it, it would be withdrawn, and then you have to sit jail on his trial. Coupled with the fact that after that, he continued to maintain some probation. That's been very consistent with Mr. Campbell. It's pretty clear that if he's done that consistently with it, everyone that we could testify, that he probably done it with Ms. Lee as well. I'd ask that the court grant this motion and allow us to proceed accordingly. Now the court said some questions that were posed earlier, and quite honestly, I can't remember specifically which ones they are. If I haven't answered them yet, or haven't spoken or addressed them yet, then we'll do that.
I don't recall from any testimony that Mr. Campbell said that that the offer was going to be withdrawn. Is that's y'all's recollection that he said it was going to be withdrawn, or that he'd be sitting in custody for over a year if he didn't take it?
It's my recollection based on what I've heard and what we discussed more than once, that he was told by Ms. Lee that the offer was taken earlier today.
I don't think he testified to that. Do you recall that, Ms. Heisel?
Your Honor, I know that I have heard that before. I can't recall clearly whether that was today or in some other capacity. I will say for the record that Ms. Lee testified that our offer was communicated in June, and the first time that she related to Mr. Campbell was October 1st. At that time, given who the felony prosecutors were, I would say that would be revoking the offer at that point would have been in accordance with our office's policy, but I was not the felony prosecutor at that point, so I can't say clearly one way or the other whether that was the case, but I have heard that claim.
So you think that there is some merit to an offer being revoked at a writ hearing? As a take it or leave it that day?
Judge, I don't know. I do think there is merit to between June and October. There being a revocation after that period of time. I don't, like I said, I'm not saying yes or no, because I don't know, I wasn't there, but that is consistent with the office's timeline of, especially if an offer for a deferred probation has been extended, if that is not accepted relatively quickly, it is our policy to revoke that.
And my recollection of the testimony is that Mr. Campbell missed court, that there was Ms. Lee testified that there was a waiver of arraignment filed. He was provided with a court date. He didn't show up. There was a KPS. He was subsequently rearrested, and that was the latter part of August. So the gap between June and say September, there is no settings with Mr. Campbell, correct?
That would be correct.
So the first setting would be the writ of habeas corpus that Ms. Lee filed on behalf of Mr. Campbell.
I believe that was the first court setting, yes, Your Honor.
My understanding is that at that point, well, I don't know when the writ was filed. But he showed up at court on August 27th. And that he was arrested. My understanding based on her testimony is he was arrested at court. So, so we went from August 27th. I guess it was 2 months after that.
So your argument is ineffective assistance of counsel on what grounds exactly? That she didn't have a lot of trial experience, that she didn't investigate the self-defense claims, that she allowed him to plead guilty when he said that he's not guilty? Is that the summary?
I think that fairly summarizes, except that she didn't have any felony trial experience at the time. I think that based on his testimony, he was under the pressure by her. So based on her testimony, he's been but Mr. Campbell has been consistent about that throughout.
And
based on the ineffective assistance, his plea was not voluntarily.
And the strong arming, what's the testimony that supports Mr. Campbell's assertion that he was strong armed?
Number one, that if you don't take this offer, you lose it today.
See, I don't think that's,
And Judge, I can recall it, but that has been a consistent.
I don't think it'd be good to recall him because he's gonna get up there and say it. Yeah,
But as an officer of the court, he said that to me.
Yeah, but it's not testimony. He had an opportunity to say that and he didn't say that. So what? I'm sure he didn't say it. I mean, we've got it recorded. We go back and look at it, and I don't know, Miss Grisham, are you able to look back on the transcript to see?
Take time, but I mean, we've done a lot of stuff since.
My recollection is that he said that he wanted to be out of jail, and she told him that if he didn't accept the offer, then he would be in jail, for a year.
I recall that testimony as well, Judge.
But,
My recollection that we also testified. If he didn't pay, he would lose. It's either there or it's not there.
Right, but I mean, it's very important though, because that's the only thing that could make a determination on whether there's a legitimate strong arm defense, strong arm allegation, if you take it today or you'll leave it for duress or coercion, but I don't recall that being the testimony. And both the state and the defense believe that there's an affirmative defense that's found in that stipulation of evidence that Miss Lee could not disagree with Mr. Campbell or any other counsel that would justify his conduct in this case. That's what you are saying?
Sorry, Judge.
We're talking about, there's been a lot of talk about, keep saying innocent, and then we're saying self-defense. And those are not the same thing. Innocent is no culpability, but what I'm really hearing is affirmative defense of Mr. Campbell being in the middle of a roadway, and even Mr. Crawford's recitation of what Mr. Campbell told him was that he went to his house, he got a gun, and he stood in the roadway and a truck was driving and he shot the truck. That his conduct would be justified under the law of self-defense.
Judge, I believe what you're asking is, does the state believe that it's a valid self-defense claim to state that? Based on my review of it.
And why? Why is that?
Your Honor, there was some conversation about the timing of the progression of all of this. Both of the witnesses' statements, there was also some testimony and confusion about who we were talking about. I'm talking about the two line workers that had no relation, as far as I'm aware, to either party. It's my recollection from the review of the evidence that they both said that Mr. Campbell came out of his house with the gun and approached the roadway prior to the vehicle approaching him at a high rate of speed. That is my understanding of their statement. I believe he had previously been outside the house without a gun, at some point did return to his house and retrieve a gun. But my understanding is that that was not after he had seen victims' vehicle. My understanding is that he didn't see her go inside, get a gun, and then come back out. Now we can all speculate as to why somebody might do that. He's got a gun on his property, and both of the witnesses say that she accelerates the vehicle towards him at a high rate of speed, and he fires into her radiator trying to disarm her vehicle. State believes that the valid self-defense.
So I'm looking at the stipulation of evidence, which is what the court reviewed to determine whether or not Mr. Campbell, his guilt could be substantiated by the evidence. And the court cannot accept a plea of guilty if I do not find that. And I would have to review this at the time of the plea, which I did. And I believe that he had a justifiable self-defense claim. The court would not be able to accept the defendant's plea of guilt. The stipulation that the state provided to the court, that the defendant stipulated to and put before the court, says that witnesses Cruz and Lopez came in, completed their written statements. Witness Lopez stated that he was working in a bucket truck and he heard a truck accelerating and it was charging a white male. Witness Lopez stated that he then saw the white male with a gun in his hands and heard the gunshot. Witness Lopez stated that he got out of there after he heard the shot. And then witness Cruz stated that they were getting ready to do maintenance on a pole. He stated that when his partner was getting ready to get in the buck of the bucket truck, he saw a man come out of a house with a rifle in his hand and started walking back and forth. Witness Cruz stated that the man then stood in the middle of the road like he was waiting for someone. He stated that he then saw a gray truck speeding down the road toward the guy, and when she got to him, he fired a shot at her truck. Witness Cruz stated that he told his partner to get in the truck and they were leaving, and before they left, he saw the man go into the same house he had come out of. So obviously, anytime there's an analysis on affirmative defense like self-defense, there has to be established who's the first aggressor and whether or not the threat has subsided or ended, because the first aggressor can change. And here the court read the stipulation back then and has reread it prior to today, and it appears to the court that there is no threat until Mr. Campbell goes and gets a gun and stands in a roadway and waits for a truck. And these are independent witnesses that are not connected to whoever is allegedly in the truck or Mr. Campbell. So there I'm trying to figure out how is the person in the truck the first aggressor if Mr. Campbell is safely in his house with weapons, and then he goes and he takes his gun into a roadway and then fires a shot at someone. There's nothing in here that says it was on his property. There's nothing in here that says that this has continued escalation of an event or incident. So am I reading this completely wrong? And this is the evidence that was submitted to support the plea.
You're reading it different than I read it, because one of the witnesses that you referred to said that the vehicle was charging at Mr. Campbell.
Right.
Coming over the field that I heard.
I agree, but he's in a roadway.
Judge, there's utility work going, the roadway is closed.
How do we know that?
How do you know that?
Well, okay, because it says witness crew says they were getting ready to do maintenance on a pole.
Right.
Nothing about there's a closed road, that there's utility work, and remember, all I can focus on is the four corners of this document and the testimony that was given here today.
So if we do that, Judge, we both just put the statements, then it's just as easy to assume that if someone's coming down the street in a residential area and there's somebody standing in the road, do you speed them and hit them? I mean, you can make all kinds of inferences from that. Now, the question is, what we heard is from the witness statement in there that it's sped up and charged at him. Now, there's no law that says you can't beat them. Now, if you're in the road and you know somebody's coming, you're going to confront them with a firearm. Well, obviously that doesn't make any sense. But the witness said that the vehicle charged him. He didn't discharge a firearm until that vehicle charged at him. And whatever happened prior to that, those witnesses wouldn't know. And that would have been developed at trial, had it gone to trial. In addition to that, I don't think you can say, I don't know if there's any statements in there about something. That's what I'm pretty sure. That would have been wise at the time to law enforcement as well.
What would have been?
His affirmative defense. Stuff will explain at the time of the incident. In other words, I don't think that it's inconsistent in claim at this point that he acted in self-defense.
What about the fact that the case got indicted and the DA's office has to review this for determination of whether or not there's probable cause to believe that Mr. Campbell committed an offense? And it's an affirmative defense at that point. So at some point, the DA's office had the prosecutor on the case had to determine after reading it that there was probable cause to bring forth the case to the grand jury. Grand jury reviewed the evidence, issued an indictment, and brought us to the point where Mr. Campbell pled guilty. So I think we're really what we're illustrating is that reasonable minds can differ on this. You being reasonable, me being reasonable, Miss Lee being reasonable. It doesn't seem glaring to me that we have an ineffective assistance of counsel on behalf of Miss Lee in this situation, because from the reading of it, minds can differ and it's within a reasonable zone of disagreement. So you've answered my question. And so Miss Lee was ineffective And therefore he didn't knowingly enter into it because I'm assuming he didn't know that he could allege his affirmative defenses. And that she strong-armed him into taking it, despite his own testimony that he wanted out of jail that day. Correct?
Well, and whether to speak that. Content of the actual testimony, right, election is different. I don't know. I could recall, at least I think I do, that she told him it was a take her in the drill. That's my recollection. So, under those circumstances.
Judge, I think we got a couple of things before us here. The state really takes no position on this treatment. Which obviously state has no knowledge of what his and Miss Lee's conversation was outside of what was offered in testimony today. The state doesn't have a strong position on this, on that issue. Our issue is more, I now, as a prosecutor looking at this case, think that I would have handled it differently. Now, that may or may not be a legal justification to undo what we've done, but I just want to make clear it's really two separate issues that's before the court. And so that's our position moving forward.
And Mr. Schmidt, you said you have filed an 11072 writ.
Yes.
Where is that at? Because it's not on file with the clerk. Do you have a copy of it? Unless they've named it something other than motion to withdraw guilty plea. What's the date on it?
I think they named it already.
It has to be theoretically filed as a writ and joined to the case.
Oh, okay. What's that writ number?
00088.
That's what it is.
There's exactly what it is, essentially the
Same.
same content.
You said WR 2288?
88.
3 zeros?
George, I don't see it written in the first.
I do see it. All right, the court has reviewed the application for writ of habeas corpus seeking relief from final felony conviction, community supervision under CCP 11.072, along with the motion to withdraw guilty plea. The court has considered the arguments of counsel and the testimony given by Ms. Shunda Lee, former criminal defense counsel for Mr. Campbell himself, Mr. Crawford, community supervision officer, Ms. Bryant, community supervision officer. Consider the arguments of both state and Mr. Schmidt. The court is unable to find that Ms. Lee has provided ineffective assistance of counsel today based on the testimony and evidence before the court to render the defendant's plea of guilty in this case to be entered unknowingly or involuntarily. Court also finds that the evidence is insufficient to prove to the court that Mr. Campbell was forced or placed under any kind of coercion or duress to entering his plea of guilty to the charge for which he has been placed on community supervision for. So the court's going to deny the motion to withdraw the guilty plea. The court's going to deny the requested relief under the writ of habeas corpus, and court finds that denying the motion to withdraw the guilty plea does not give Mr. Campbell appellate remedy, but he does have an appellate remedy on the application, denial of the application for writ of habeas corpus. And that's why I wanted to review that so that he has the right to appeal the court's ruling. I think the only other issue now is to reset Mr. Campbell for another hearing, give Mr. Campbell counsel time to decide if there's going to be an appeal, and to give you time to perfect appeal, and if not, then to move forward with the next step. Okay, so Mr. Schmidt, I got a contested hearing in November, do not have one in December. The next one after that would be January 26th. We could either do November 29th or January 26th.
I don't recall before when the state law made the draw and terminated that.
Let me go back and see if I actually signed an order on that. Must have reset it because I didn't grant or deny the proposed order on motion to withdraw. So you want to rely on that?
Yes, sir.
All right. Court will deny the state's motion to withdraw the motion to adjudicate.
And finally, there's also, we had agreed for PR bond, I think, court last time the grand asked for. I don't think we ever received that. I don't know if we have rules. And years, the request for PR bond is signed. And the resolution.
My court's going to deny the request for a personal bond or personal recognizance bond. Court finds that the state alleged that Mr. Campbell failed to report while he was on community supervision, so I'm not confident that he would return to the jurisdiction of the court. And I'll issue a written order on that for you as well. Okay. Yes, are we ready on Mr. Freeney or Mr. Gutierrez? All right, Mr. Freeney. All right, Mr. Freeney, if you raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, thank you. You can put your hand down. Mr. Freeney, your name is Benson Lerone Freeney, is that right? And Mr. Freeney, I see that you appeared before the court previously on this charge of possession of a controlled substance between 4 grams and 200 grams, a second-degree felony. You appeared on May 1st, May 21st of 2015. Court heard the evidence, found there was enough evidence to convict you of that offense. The court that day followed a plea agreement that you reached with the state. The court convicted you and assessed your punishment at 10 years confinement in prison and ordered you to pay a fine. The court then suspended that sentence and placed you on community supervision for 10 years. And it was during your period of community supervision that the state has filed a motion to revoke, and they have alleged in 10 separate counts ways that they believe that you have violated your community supervision. Have you had an opportunity to review that motion with your attorney, Mr. Schmidt? You feel like you've had enough time to talk with him about this case, about these allegations and what your rights and options are? And do you feel like you understand everything that you and he discussed and what you signed in this paperwork? And are you pleased with his representation of you? All right, and Mr. Schmidt, does your client waive the formal reading of the state's motion to revoke? And is it his intent to plead true to all counts? And you've explained to him the motion and his rights as they pertain to this proceeding, is that right? And do you believe that he understands what he's doing today, that he's competent, that he's entering into this intentionally, knowingly, and voluntarily?
Yes.
Okay. Mr. Freeney, I see the plea agreement in your case is that you would plead true to all of these counts in exchange for the state's recommendation that your community supervision be revoked, that you be sentenced to 4 years confinement in the Texas Department of Criminal Justice, and that you be ordered to pay the remainder of your financial obligations, including fines and court costs. And in part of this plea agreement, you would receive 436 days credit towards your sentence for the time that you've already spent in jail. Is that your understanding? And that's what you want the court to approve today? Okay. All right, Mr. Freeney, then how do you plead to counts 1 through 10? Are those counts true or not true? True. Do you need to see them? Okay, you had some hesitation about you. Is there, you got a question, or you sure? I can give you time if you have questions for me or Mr. Schmidt. No, just a tough decision to make today. You're good. All right, Mr. Freeney, you pled true to these counts. Are you pleading true because everything alleged is in fact true? And you're not just telling me that so that you can get a 4-year sentence rather than running the risk of getting a 10-year sentence, right? And you're going to speak up so my court reporter can hear you.
No.
Okay. All right. Court will accept the defendant's pleas of truth to each count. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of truth?
No.
All right, that will be admitted, and the court will take judicial notice of Mr. Freeney's judicial confession. Anything further from the state, from the defense? All right, Mr. Freeney, based on your pleas of true and the evidence submitted, the court will find that you have violated the terms and conditions of your community supervision. The court will revoke your community supervision, follow the plea agreement you've reached with the state. Court assesses your punishment at 4 years confinement in the Texas Department of Criminal Justice Institutional Division, orders you to pay the remainder of your fine, court cost, And the court will order you to receive 436 days credit towards your sentence for the time that you have spent in jail on this files. All right, Mr. Freeney. You're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Maybe step around here with Deputy Everett, take your fingerprint. Mr. Gutierrez.
Good to know, the results of the court that we're intending to do. This year, implement the and the state is also tended to motion to dismiss the aggregate.
Okay. Mr. Gutierrez, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Okay. What happened to your eye?
Oh, ran into something.
Ran into something or someone?
Kind of sort of both.
Yeah. Are you okay?
Got a doctor last night, that's good.
Everything's good. So you've got medical treatment while you've been at the jail?
Absolutely.
Okay. All right. Mr. Gutierrez, are you a United States citizen?
Yes,
Do you read, write, and speak English?
yes, I do.
And have you ever been diagnosed with any type of mental condition?
No,
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt's representation of you?
very much.
Do you feel like you've had enough time to discuss these cases with him to the point that you've had all of your legal questions answered?
Absolutely.
Is there anything about this paperwork that you've read and signed over today that you do not understand?
No,
And Mr. Schmidt, do you believe Mr. Gutierrez to be competent and that he's entering his plea today intentionally, knowingly, and voluntarily?
I do believe he is competent, yes.
And you have explained to him his rights as they pertain to these cases?
I have.
And Mr. Gutierrez, I see here, as Mr. Schmidt has informed the court, that you are allowing the state to prosecute you for bail jumping and failure to appear on the basis of an information. This is a felony charge which can only be brought to court if it's presented to the grand jury and the grand jury determines that there's enough evidence to believe that you committed the crime before an indictment could be filed in this court and you can be prosecuted. However, you would be waiving that today, correct?
Yes,
And you've talked to Mr. Schmidt about that. You understand that that's a right that only you can waive. Nobody can waive that for you, and nobody can make you waive that right.
I understand that for the fullest.
Okay. And understanding that, you're telling the court you want to waive your right to a grand jury indictment and proceed on resolving this case by way of an information.
Absolutely, I do.
Okay. All right, and I see, Mr. Gutierrez, that the plea agreement is that you've been you've been charged by information with bail jumping and failure to appear. However, the plea agreement is to reduce that charge to a state jail felony offense of attempted bail jumping or failure to appear, and that your prosecution would proceed under section 1244A of the penal code, which means that you would be convicted as a felon for that offense, but you would be punished as a misdemeanor offense. Is that your understanding as well?
It is.
And that
Judge-
you were,
Judge, I don't mean to interrupt, but I do believe I intended to file the information as attempted bond jumping. You may want to look in the actual language of the charging instrument. I believe it was filed as attempted bond jumping.
okay. Yeah, you're correct. The docket just says bail jumping F3. So the information that they filed, Mr. Gutierrez, does say that it's an attempted state jail felony bail jumping, not a third degree. So it wouldn't be a lesser included offense. It would just be the offense that they've charged you with, a state jail felony offense. You understand the distinction?
Yes, I do.
Okay. And the punishment, according to the plea agreement, is that they would recommend upon your plea of guilty, 365 days in the county jail, you would receive credit for that time served, and they would be dismissing a couple of other cases that are criminal mischief cases. And you would be ordered to pay court costs and reimbursement fees. You understand that as well?
Yes, I do.
Okay. All right. So understanding the in the range of punishment for a 1244A bail jumping would be a maximum 365 days in the county jail and a fine not to exceed $4,000. So the court would find that the plea agreement would fit squarely within the legal range of punishment. So understanding those things, Mr. Gutierrez, I would ask you, how do you plead to attempted bail jumping and failure to appear?
I plead guilty.
And you plead guilty to that crime because you are guilty of committing that crime?
Yes,
And has anybody threatened you, forced you, pressured you, otherwise made you feel like you had to plead guilty?
absolutely not.
The court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence? State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state, Mr. Woodwhite?
No, Your Honor. We would ask that you follow the plea agreement.
All right. Anything else from the defense?
No.
All right, then based on the. And also there's an agreement that, or the state has tendered a motion to dismiss in CR 21-6A. That's not a 1245, but a straight dismissal, correct?
That is correct, Your Honor. I'm kind of having network problems. I'm not sure if you can hear me still. Mr. Schmidt, Mr. Gutierrez was represented by a separate attorney. Mr. Schmidt brought a number of legal challenges to that charge, and we are agreeing to dismiss it at this time.
Okay. All right, then based on the evidence, court will find that there is sufficient evidence to convict Mr. Gutierrez of this offense. Court will follow the plea agreement. Court hereby convicts Adrian Gutierrez of attempted bail jumping and failure to appear. Court finds that that is a state jail felony, and the court will assess punishment under section 1244A of the Texas Penal Code at 365 days in the county jail. The court will award Mr. Gutierrez credit for time served in the amount of 365 days, and the court will dismiss under section 1245. Cause number 2021-176 criminal trespass and 2021-102 criminal trespass, and the court grants the independently filed motion to dismiss in CR 21-68, which I believe is aggravated assault with a deadly weapon. All right, Mr. Gutierrez, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence, and then come forward to be fingerprinted with Deputy Everett. And Ms. Heisel, I'm gonna need your signature on these papers. You come on up, sir.
Thank you.
Are we good?
Yes, sir. Thank you, Mr. Gutierrez.
Thank you, Your Honor.
You're welcome. Be careful in there.
Yes, sir.
Surely not. Let's see what we can find for Mr. Sean. Mendez, you removed, correct?
Yes, sir.
Mr. Gutierrez. Mendez, Esteban Mendez, Mr. Schmidt asked for the motion to be removed. Holman. Yes, sir. Appreciate you. See you. Mr. Manning.
contact you tomorrow, next day or something? Well, I just want to make sure.
We can get, they can go. You're free. Oh, she's making copies. Mr. Manning, I'm ready for you when you are.
Yes, Judge, ready on Mr. Quintanilla as well as Mr. Griffin.
All right, Mr. Quintanilla. Sure. All right, it's cause number CR 2131, State versus Christopher Dillon Quintanilla. And is this a plea today, Mr. Manning?
That's correct, Judge.
All right, and it's a motion to adjudicate. All right, can you go ahead and give me the terms of the plea?
Yes, Judge, he'll be pleading to the state jail possession of controlled substance less than a gram. Upon a plea of true, defendant's guilt will be adjudicated, community supervision be revoked, punishment assessed at 6 months state jail with balance financial obligations. The fines, $4,000, restitution, $115, court cost is $0, and reimbursement is $54.91. Judge, I would ask, my client has 269 days credit. I'd ask that his remaining time of credit above the 6 months be applied to his fines and court costs.
All right, the court will take that under consideration. Give me a second. Let me pull up his motion there.
Judge, we have a copy of the motion here if you would like for us to just go over it.
Oh, well, I like to read from it so I can admonish him, so it'll take just a second. And it helps me to make sure that I'm doing what I need to be doing.
And Judge, additionally, I don't know how the state intends to proceed, but my understanding is that Mr. Quintanilla just pled to count 1 in Coffin County. I think the remainders of those cases were either dismissed or 1245. So I don't know if they're going to proceed on those.
State would be willing to abandon the cases that he did not plead on. I believe they were 1245, but state would abandon all but the first, but count 1 of the new offenses. I'm trying to pull it up myself.
Is it here? It is right here. Can you see this? You see that motion?
Yes, Your Honor.
All right, so while you're looking, Mr. Quintanilla, if you'll raise your right hand, sir, I want to place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. Just make sure you speak up a little bit louder for me, Mr. Quintanilla. You are Christopher Dillon Quintanilla, correct?
Yes, sir.
Mr. Quintanilla, I'm showing you the motion to adjudicate and revoke filed by the state. Says here that on May 27th, 2021, you appeared before the court, pled guilty to the state jail felony offense of possession of a controlled substance. Court heard the evidence, found that there was enough evidence to convict you. However, the court deferred a finding of guilt, placed you on 3 years community supervision, and ordered you to pay a $4,000 fine. During your community supervision period, the state has filed a motion to adjudicate and revoke and has alleged 11 separate counts of ways that they are alleging that you have violated the conditions of your community supervision. Have you had enough time to review this motion with your attorney, Mr. Manning?
Yes, sir.
It's my understanding that you're going to be pleading true to some of these counts and that you're asking the court to approve a plea agreement today. Is that right?
Yes, sir.
And do you feel like you've had enough time to talk with him to the point that you understand everything that you've read and signed and you have no more legal questions?
Yes, sir, I have.
Okay. And you are pleased with him and his representation, is that right?
Yes, sir.
And Mr. Manning, do you believe Mr. Quintanilla to be competent today and that he's also entering his plea intentionally, knowingly, and voluntarily?
I do, Judge.
All right, and so for the record, state which count is the state abandoning in this motion?
State is abandoning 2, 3, 4.
2, 3, 4.
Yes, Judge.
Okay. And Mr. Manning, did your client waive the formal reading of the remaining of the state's motion and remaining counts?
He does, Judge.
All right, Mr. Quintanilla, I'm going to ask you at this time, how do you plead to counts 1 and then 5 through 11 as contained in the state's motion to adjudicate? Are those counts true or not true?
True.
You know, you telling me that those counts are true because in fact, everything that they said in there is true. You're not just saying that so you can get a certain plea agreement. Is that right?
Yes, sir.
All right, the court will accept the defendant's plea of true as to counts 1 and 5 through 11 in the state's motion. Court will find that the state has abandoned counts 2, 3, and 4. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Rest in close, Judge.
All right, Mr. Quintanilla, based on your pleas of true to those counts, court will find that you have violated the terms and conditions of your community supervision. The court will follow the plea agreement you've reached with the state. Court hereby revokes or adjudicates your guilt, convicts you of the state jail felony offense of possession of a controlled substance in felony group 1, less than 1 gram. The court assesses your sentence at 6 months confinement in the state jail division of TDC. The court will order you to pay the balance of your financial obligations, and the court will award you 269 days credit towards your sentence for the time that you have spent in jail on this cause. And Mr. Manning, so I think you referenced Mr. Quintanilla had other charges, perhaps in Coffin County, which would account for his overage on jail time credit.
Judge, part of his jail time credit was his time incarcerated in Coffin County while he had a hold pending from Van Zandt County.
Okay. Okay. All right, and the court will take the defendant's request for credit on those on the remaining days towards his financial obligations. Mr. Quintanilla, once you're released from the state jail division of TDC, I want you to report to the Van Zandt County Courthouse and meet with a court compliance officer, and I will make a determination at that time, and may also consider allowing you to discharge your fines with community service. Okay. All right, Mr. Quintanilla, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over to be fingerprinted. Good luck to you, sir.
Real fast, you need me to stay here in the courthouse. I gotta get the developments.
We'll make sure we have election integrity. Your next client, Mr. Manning, said
Mr. Griffin.
Griffin. All right, Mr. Griffin, if you'll come on up, sir. Jesse John Griffin, CR 22-215. Are we doing a plea or a writ today?
Judge, we're proceeding on the plea and abandoning our writs.
Okay. All right, so go ahead and give me the terms of the plea.
Yes, Judge. Before I do, just by way of correction, the judgment states that this was charged by information. It was in fact charged by an indictment. If we could get a corrected front page of the judgment. The state's proceeding under a theft of property with 2 or more previous convictions that was enhanced to a 3rd-degree felony under repeat felony offender status. The range of punishment for that is 2 years to 10 years. And I've advised my client of that range of punishment. His plea is going to be guilty with punishment assessed at 3 years in TDCJ 1245 DA cause number 2022-0450, which is a additional theft of property of the same type. His plea to the enhancement paragraph is going to be the first enhancement paragraph is going to be true, and he has no fines, no restitution, court costs the amount of $290, and reimbursement in the amount of $20. Additionally, Judge, he has 198 days credit at this time, and this sentence is showed to run concurrently with any and all other sentences.
All right, thank you, Mr. Henning. Mr. Griffin, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, sir.
All right, you can lower your hand. Your name is Jesse John Griffin, is that right?
Yes, sir.
And Mr. Griffin, you heard the plea agreement that Mr. Manning laid out before the court. Is that the plea agreement you've reached and what you want the court to approve today?
Yes, sir.
Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Post-traumatic stress disorder.
PTSD?
Yes, sir.
And are you currently undergoing any type of treatment or on medication for PTSD?
No, sir.
Do you feel like you have a rational understanding of the proceeding as it is occurring today to the degree that your PTSD is not clouding your judgment or your mind or your ability to understand?
Correct.
Okay. And you're represented by your attorney, Mr. Manning. Are you pleased with his representation of you?
Yes, sir.
You feel like he has answered all your legal questions and you've had enough time to talk with him about your options?
Yes, sir.
Okay. And Mr. Manning, do you believe Mr. Griffin to be competent today and that he's entering his plea intentionally, knowingly, and voluntarily?
He is, Judge.
You've explained to him his rights as they pertain to this case?
I have.
All right, Mr. Griffin, you are charged by indictment with a theft of property less than $2,500 with 2 or more previous convictions with an enhancement paragraph, which if proven true would increase your range of punishment to that of a repeat felony offender with a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a fine not to exceed $10,000. I would find that the plea agreement that you've proposed to the court would fit within the legal range of punishment. So I would ask you at this time, Mr. Griffin, how do you plead to theft of property less than $2,500 with 2 or more previous convictions?
Guilty.
And how do you plead to the enhancement paragraph that they've alleged in the indictment? Is that enhancement allegation true or not true?
True.
And are you pleading guilty to the indictment, and are you pleading true to the enhancement paragraph because you are guilty of committing that crime and the enhancement information is in fact true?
Yes, sir.
Mr. Griffin, has anybody threatened you, forced you, pressured you to make you feel like you had to plead guilty today?
No, sir.
The court will accept the defendant's plea of guilt. And Mr. Manning, any objection to the state's evidence?
No objection to state's one.
States 1 stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Further from the state?
No, Your Honor. There is no restitution requested because the property was recovered. And yeah, state would ask that the court follows the plea agreement.
Thank you, Mr. Woodward. Anything further from the statement or from the defense, Mr. Manning?
Rest in post, Judge.
Okay. All right. And then Mr. Woodwhite, can you give me the facts that support the plea?
Yes, Your Honor. On April 10th of this year, the defendant is caught by a Tractor Supply employee walking out of the front door of the store with 2 machetes. And CPD responds. They arrest him on the way to the jail. He's Mirandized. Says he is just trying to survive, and he was stealing the items to sell them to survive. That would end the state's summary of this charge.
Anything further, Mr. Manning?
Judge, I would just note with this that Mr. Griffin was found camping out in the area, and he was in fact just trying to survive. I spoke to him about his plans once he gets out, and I believe he's gonna be able to get on some firm footing once he leaves TDC. But he was in a tough spot, and he's taking responsibility for his actions, and hopefully this will be a final chapter in this time of his life.
Thank you, Mr. Manning. I hope that's true, Mr. Griffin. All right, the court, based on the evidence presented, finds that there is sufficient evidence to convict Mr. Griffin of this offense. The court will follow the plea agreement. Court hereby convicts Jesse John Griffin of theft of property less than $2,500 with 2 or more previous convictions. Finds the enhancement paragraph to be true. Court assesses the sentence in accordance with the plea agreement at 3 years confinement in the Texas Department of Criminal Justice. Orders a 0 fine, $290 court cost, $20 reimbursement fees, The court will dismiss under section 1245 DA 2022-450, and the court will award Mr. Griffin 198 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Griffin, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over to be fingerprinted. Good luck to you, sir.
And Judge, will we be able to get a corrected copy of that front page of the judgment?
State will provide a corrected copy both to Mr. Manning through email, and I will bring a copy to the court for inclusion that does say it was charged by indictment instead of information.
Thank you, Mr. Levi. Anyone else, Mr. Mason?
Yes, Judge. I guess we can just go right down the line. Let's start with Mr. Roberts. Judge, we've reached an agreement on Mr. Roberts in regards to his bond reduction. State's agreed to reduce his bond to $5,000 cash or surety. And we are in agreement with that reduction.
Okay, all right. Court will approve that agreement and will set the bail at $5,000 cash or surety. Court will sign that order and have it sent over.
Thank you, Judge.
Sure.
Judge, next we have Mr. Pitts. We've also reached an agreement on that one to reduce his to a $10,000 bond cash or surety.
Okay.
And Judge, the state is going to ask for an additional condition on his pretrial release that he have no contact with minors outside of CPS approval / supervision. But other than that, state is in agreement.
Is that no contact with minors involved in the CPS case or minors in general?
Your Honor, I'm aware that Mr. Pitts has a couple of children. That is primarily who I'm concerned about. However, given the facts of the case, state would request that it be minors in general outside of CPS approval or supervision.
Okay.
And Judge, I don't know about if the case lends itself to that broad of a restriction. I would understand why the state would not want him around the children that are currently in CPS's care. So we would ask that it be limited to individuals that are a part of his family. Just so it's not so broad.
And I think that's what you clarified, Ms. Heisel, correct? I think I asked all children or just children that are involved in the investigation. And I probably misstated it, but I think Ms. Heisel corrected me and said just those that are under the CPS care. Is that correct? Which would be his children?
Your Honor, state's comfortable with that.
Okay. All right. And so if that's not reflected on the conditions of pretrial release, then the court will order that as an additional condition and will assign the agreed order on the bail reduction to 10,000 cash or surety.
Yes, Judge. Judge, we do have a clarification on that additional condition that was added by the state. If CPS chooses to release the children back to Mr. McInturf and his wife, who is a co-defendant in this case. I'm sorry, Mr. Pitts in this case. Would the state condition his being around his children on CPS's investigation?
So the request from the state is that the contact be limited as ordered by CPS. So if CPS returns the children, the state has no objection to that. I'm just saying follow whatever CPS says.
Okay, and I just want to make sure we were clear. My client had that question, and I want to make sure that was clear on the record.
So this is what I'm gonna do. I'm gonna do a good judge's move. I'm gonna say, please send over the condition as y'all wanted to read. And then I will sign that. Otherwise, I'm not sure I'll get that accurate.
If Ms. Hines will forward it to me and to the court, I'll let you know if that comports with what our thing is.
And you can forward that via email and get your language. And then as long as I have that, then I can amend the conditions to reflect y'all's agreement. All right. So who is it?
This is Mr. McInturf. State has agreed to reduce the bond on his possession of controlled substance from $20,000 to $7,500 cash or surety, and to give a PR bond of the same amount in the tampering of physical evidence.
Okay. Court will approve the agreement of parties. Court hereby sets bail at $7,500 on the possession charge, cash surety, and the court sets a $7,500 personal bond on the tampering or fabricating with physical evidence.
And Judge, I would ask that if Mr. McInturf is unable to make the bond, permission to reintroduce a request for PR bond at the expiration of the 90 days.
Court will allow you to file another writ, and court will consider that.
Thank you, Judge. Thanks, sir. Judge, ready on Mr. Sewell.
All right, court call CR 22-253 State versus Dustin Allen Sewell.
Judge, file a writ on his case for bond reduction. My understanding is that he has two holds here in Van Zandt County. One is for a $20,000 possession of controlled substance, and one is for a $5,000 resisting. My understanding, through checking through the files in the court system as best I could, that the resisting has not been filed, and so we request a PR bond on that, and then we would ask a reduction of $10,000 for the possession of controlled substance.
Do you want to call your client?
Yes, Judge.
All right, Mr. Sewell, if you raise your right hand.
And Judge, I think I can save us a hearing. I'd stay willing to agree to Mr. Manning's proposed request, the misdemeanor PR and $10,000 on the state jail meth case.
Okay, what about the resisting arrest or search or transport? What's the agreement on that?
A PR bond, Your Honor.
PR. And let's see, Mr. Manning. I'm not sure I have an order on the other charge for Mr. Sewell. This is all I have on Sewell. It's just that one.
Judge, and I believe that my appointment had been amended on Mr. Sewell, and that may have been filed in the county court of law. I'll see if I can track down that order, or if not, send an amended order, or if the court wants they can interlineate, we would have no objection to that.
All right, I'm just going to write it in. Is there a DA control number or something? What is the jail going to be able to look at to know what's the alleged offense date on the possession of controlled substance?
Judge, I believe that is January 2nd.
Judge, it's going to be May the sheriff's office has it listed as May the 3rd of 2022 on both the state jail possession of a controlled substance and the resisting arrest, search, or transport.
Okay.
And Judge, the reason for my pause is that it listed the alleged date of offense of 2002, so I knew something was not quite right.
And what was the agreement on the amount for the possession of controlled substance?
10,000, Your Honor.
Surety or
Cash or surety.
cash or surety? Jail's probably gonna hate me for all my chicken scratch, but
Luckily, we have a member of the jail staff here who has a steel trap memory.
all right, so that's there, Mr. Sewell. Thank you, Mr. Sewell.
Thank you. Don't get the schedule. Judge, I'm ready on Mr. Vigil. I believe that's gonna be agreed reset based on the unavailability of the witness today. I don't have any reset forms with me. And I don't have someone from the court staff here. So if we could execute a reset form, I can come by and pick that up when I drop off the judgments.
All right, court will reset Mr. Vigil for the contested docket on Tuesday, November 29th.
Judge, ready on Mr. Ozuna.
Okay. All right, this is cause number CR 22-282, State versus Richard Ozuna.
Yes, Judge. I believe we have an agreement as to a partial agreement. There's an unfiled. One of the unfiled aggravated assaults with a deadly weapon. I'm not sure which bond is connected to which case. And I would have to rely on the DA's office to clarify that. But whatever one has been unfiled, my understanding is that they are willing and ready to agree to a PR bond as it has been past 90 days on that one. Additionally, Judge, we'd like to have a hearing as to the other one, as my client has been unable to raise funds to secure a bond in this situation.
Okay. All right, Mr. Ozuna, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Just make sure you speak up loudly and clearly for me. Go ahead, Mr. Manning.
Mr. Ozuna, can you state your name for the record?
Richard Eleuterio Ozuna Jr.
Okay, and Mr. Ozuna, how long have you been in Van Zandt County Jail on these charges?
About 4 months now.
Okay, would it be true or correct to say that you were arrested on or about June 9th of 2022?
Correct, sir.
Okay, and your bonds are set currently at $300,000 and $150,000. Is that correct?
Correct, sir.
And do you understand that of those two charges, one of those is going to be PR bond? We're waiting confirmation on which one. But the other one, the bond, is still in place as the case was filed timely by the DA's office.
Yes, sir.
Okay. And can you afford either one of those bonds, $150,000 or $300,000?
No, sir.
Okay. And do you have any assets that you could use to post a bond? Like, do you own a home?
I own a car,
Okay. What kind of car do you own?
a Kia Soul, sir.
And approximately how much do you think that Kia Soul is worth?
About 10 grand.
Okay. What year is it?
It's a 2013.
And besides the Kia Soul, do you have any other property you could sell or put up as collateral to help assist in making a bond?
No, sir.
Okay. Do you have any family members that have tried to attempt to help make a bond in these cases?
No, not yet.
Okay. Has your family been in contact with my office attempting to get you a situation where you can make a bond?
Yes, sir.
Okay. And have they been successful at this point in reaching an agreement with the bondsman to bond you out in this case?
Yes, sir.
They have not.
No. No,
Okay.
no, sir.
Have you ever been charged with bail jumping or evading arrest?
No, sir.
Okay. Have you ever missed a court date?
No, sir.
Okay. And if the court gives you a bond reduction that you can make or a PR bond, would you commit to coming to court to continue fighting these charges and presenting a defense?
Yes, sir. I
Okay.
will.
And you understand that if you're given a bond, that the court may require certain things upon you, would you be willing to abide by whatever conditions the judge puts on you if he so orders that?
Yes, sir.
Okay. And you realize that one of those conditions may be that you have to wear an ankle monitor, or one of those conditions may be that you have to report to the pretrial release office. And you'd be willing to do that and
Yes,
pay
sir.
the associated fees.
Yes, sir.
Okay. Prior to being arrested, did you have a job?
Yes, sir. I did. I live in San Antonio, Texas.
And if you get out, would you be able to continue working?
Yes, sir.
Okay.
I'm sorry, Mr. Manning, can you have him repeat what he said? We couldn't hear him.
Which part, Judge?
Where he works and if he has a job. Was he working before he got arrested?
If you can just speak up.
Oh, I live in San Antonio, Texas, landscape, sir.
Thank you.
Judge. And Mr. Ozuna, if you were released, you understand that you would need to stay away from the victim.
Yes, sir.
And you would most likely accomplish that by going back to your home in San Antonio. Is that correct?
Yes, sir.
And the reason you were up here was you were visiting your family. Is that correct?
Correct, sir.
Your father and other members of your family that lived here in Van Zandt County.
Yes, sir.
Is that correct? Okay. You are not pass the witness.
Ms. Heisel?
And Your Honor, before I have a couple of questions for Mr. Ozuna, just for the record, for clarification, the state is agreeing on the $150,000 bond to a PR. I have a DA control number and an agency control number if the court would like those.
Yes, go ahead.
DA 2022-1009.
Okay.
And then the agency case number is 22-15620.
Thank you. All right, any questions? Mr. Ozuna?
No, Your Honor, Mr. Ozuna just answered state's only question, so we're good. Thank you, Your Honor.
All right, you want argument, Mr. Manning?
Judge, just as I said before, Mr. Ozuna has not had a record of failing to appear to court. He has explained where he'll be living, where he'll be working. He agrees to abide by the conditions of the court. $300,000 bond is excessive in this situation, based not only on the charges alleged, but the means that Mr. Ozuna has. He said his only asset at this point in time was his vehicle, which he estimated to be approximately $10,000.
Thank you, Mr. Manning. Ms. Heisel, any argument?
Your Honor, state left for the court, it's a little out of order, but state would offer at this time the PC affidavit in this cause. I left it with Deputy Everett at the courthouse.
Does Mr. Manning have a copy of that?
I provided I don't believe I provided Mr. Manning a copy of it, but I did provide him access to my copy this morning, and it is, I believe, on the discovery portal for him.
Judge, I have reviewed it on the discovery portal as well as discussed it with my client.
Any objection to this being admitted for the purpose of this hearing?
No objection.
All right, then the court will admit. We'll call this states. We'll call this states one. Any argument, I'm sorry, Ms. Heisel, any argument?
Your Honor, just we would ask you to review states one based on the nature of the offense and the information provided in states one. We would ask that you do hold his bond. I show it's at $350,000, but that may be a mistake on the clerk side. Given the fact that the state is agreeing to a PR on the other charge, that is already a substantial reduction in what he was being held on. We believe that amount, the remaining amount, is fair and justified given the seriousness of the offense, the charges that he's facing here in Van Zandt County, and the fact that he is not residing locally, therefore his, propensity to flee may be increased, Your Honor.
All right, thank you, Ms. Heisel. All right, the court's going to take the evidence and arguments under advisement, and I'll issue a ruling at the conclusion of my docket today.
Yes, Judge. I'll be honest now, but-
You ready on anyone else, Mr. Manning?
Judge, I believe, the last one I have is Mr. Smith.
All right, court calls Clarence William Smith and all his cases. And do you want to call Mr. Smith as a witness today for this hearing, or do you have an agreement?
No, Judge, we do not have an agreement, and if I may, call Mr. Smith for purposes of this hearing and this hearing alone.
Mr. Smith, if you'll raise your right hand. Mr. Smith, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Just make sure you speak out loudly and clearly for me so I can hear you. Go ahead, Mr. Manning.
Mr. Smith, please state your name for the record.
Clarence William Smith III.
Okay, and Mr. Smith, you understand that you've been charged with and indicted on eight cases, correct? Yes, sir. Okay, but you were being held for $18 cases, is that correct as well? Yes, sir. Okay, and when were you arrested on the original charge? March 16. Okay, and have you been in continuous custody since that time of the offense? Yes, sir. Okay, do you know when you were indicted on the offense from March 16th? If I were to show you a copy of the indictment, it appears that you were indicted on August 19th of 2022. Is that correct? Yes, sir. Okay. And had you been in custody more than 90 days at that, continuous custody more than 90 days at that time? Yes, sir. Okay. And had you requested a court-appointed attorney prior to those 90 days passing? Yes, sir. Okay. And when did you receive my services as your attorney? Just before I got it on 8/29. Okay. And that was after you had been indicted, is that correct? Yes, sir. Okay. And as far as you're aware, none of the other charges besides those 8 charge cases have been indicted, is that correct? Correct. Okay. And do you know what the date of offense is for some of the remainder of those cases? Do you know when they added those additional charges? Around June. Okay. If I said it appeared they added them on June 28th of 22, would that be a correct statement? Yes, sir. Okay. And have you been able to make a bond in any of these cases? No, sir. Okay. And are you able to make any type of bond on any of these cases? Not at the moment. Okay. Your Honor, before we proceed, is it your understanding that the alleged victim in this case no longer lives in the state of Texas? Correct. And is it your word that you would not contact this victim in any way, shape, or form if you were released? Correct. Your Honor, I pass the witness.
Questions from the state?
Mr. Smith, what is the relation of the alleged victim in this case to you?
Stepdaughter.
Are you and her mother still married?
At the time, we're in divorce.
Okay. But you are still currently married?
Yes.
Okay. Your Honor, I would pass the witness.
Judge, by way of argument, none of the cases that are pending before Mr. Smith were timely indicted or filed within the 90 days, and we'd ask for PR bonds on all of those cases.
Okay, and Ms. Heisel?
Judge, if you would give me just a second, sorry, there's a lot of cases here. If you give me just a second to fact check one thing Mr. Manning said. Judge, I show that all of these cases returned an indictment on August 19th of 2022. I agree with Mr. Manning as to the continuous sexual abuse with the alleged offense date. I believe it was in March, that was not indicted within 90 days. However, I believe the rest of the cases that are indicted have an offense date of June 28th. That is when the hold went out. So I do believe that those were indicted within 90 days. So the state's request to the court is going to be to grant Mr. Manning's request as to cause number CR 22-00285. As well as the charges that are Mr. Smith is being held on but are unindicted. And the state would ask the court to retain the bonds where they are on the following cases. Let me know when you're ready.
I'm ready.
Okay. CR 22-289, 287, 291, 290, 286, 288, and 292. I apologize to the court that our system doesn't put those in chronological order.
Judge, by way of clarification, I believe that one of those cases that Ms. Heisel listed out, the bond is shown to be a $150,000 bond. That also has an offense date and arrest date of March 16th of 2020 as per the jail screen. And Mr. Smith would be entitled to a PR bond on that one as well.
And Your Honor, I'm going to again disagree with Mr. Manning slightly. I show that the it is possession of child pornography, that's the charge, but I show that the state has declined the charge for the March 16th offense date. It is not one of the indicted cases.
Do we have a status on the obscenity case?
I show that that was declined by the state as well.
So the remaining bonds are all set at $10,000. Is that correct?
I believe that is correct.
So I'm showing about 15 cases of possession of child pornography set at 10,000 apiece. And then, so the sexual abuse of child continuous victim under 14, that's the 150,000 that is greater than 90 days, no indictment.
Correct.
Agreeing to personal bond on, and then you're telling me that the obscenity was rejected by the state.
That is correct.
And so, and also the one of the possession of child pornographies dated 3/16/2022 with bail set at 150 was also rejected.
Correct, Your Honor.
Okay.
So there should be 7 possession of child pornographies that I believe are all set at 10,000 apiece. That is what the state is asking you to not lower.
You say 7? So I'm showing 15.
Correct, Your Honor. The state indicted 7 of them, and the other 8 of them were declined by the state. So we would agree to a PR on those because they were not timely filed.
I thought all of the child pornographies were June 28th of 2022.
Your Honor, there's one that has a March arrest date. The rest of them are all June.
Right. I'm going off Mr. Manning's order. Let me just kind of show you what I'm looking at. Maybe you'll understand my confusion here. So let me see if I can use this technology here. This is Mr. Manning's order. So here's the continuous sexual abuse. That's up top. And then we have a possession that is of that date.
Correct.
Understand that that's the one you're agreeing to that is not timely. Then there's an obscenity down here that was rejected.
Correct.
Then you're telling me that out of these remaining 15, only 7 of these were indicted?
That's
And-
correct, Your Honor.
So on my docket, which pulls from LGS, it shows, okay, so that's why you read me those case numbers.
Yes, Your Honor.
Let's read those again. 'Cause
Okay.
I wasn't knowing where we were going with that, so I didn't mark. So read those case numbers to me again, and those are the ones that you're saying have been indicted timely.
Correct, Your Honor.
All right, let's
So-
do that again.
What I believe has been indicted by timely is CR 22-286, 287, 288, 289, 290, 291, 292.
Gotcha. All right, that makes more sense. Got it now. Sorry, I didn't catch that the first time.
A lot of information, Judge, no problem.
And Mr. Manning, do you disagree with Ms. Heisel on those that she's named with those cause numbers being indicted timely or untimely?
There's no disagreement as to that. She is correct that those were timely filed. Those 7 cases for possession.
And the state's asking for it to remain at $10,000 or whatever it's set at?
Yes, Your Honor.
So we would be looking at a total bill of 70,000 for Mr. Smith.
Yes, Your Honor.
That's
Okay.
correct.
Okay. All right, then the court will take it under advisement and I will mark up this order and order the ones that are agreed untimely and or rejected. I'm not sure if the sheriff's office, if they've received a rejection on the obscenity or not, so.
Judge, I haven't received any information that those have been rejected.
So I'm just going to go ahead and write personal bond on those as well in the meantime. And then that'll allow time for the paperwork to get over there. Okay. Anything else from Mr. Smith?
Nothing from a defense.
Okay. All right. Thank you, Mr. Smith. We'll be adjourned in your case.
Thank you. Judge, I believe that concludes my business. May I be excused?
It's been a long afternoon. You may be excused. I, on the other hand, will forge ahead and I'll have more.
Judge, are there any more here at the jail or do you want me to shut this system down?
Let's see, Mr. Ashmore
We should have Mr. Hamden.
is Mr. Hamden should be in the jail.
I'm getting indication that he is.
Okay. Yeah, if we can go ahead and bring him in, then I'm going to bring Mr. Ashmore in.
Judge, I'll bring the judgments over as soon as I leave this place.
Ms. Abraham says she'll meet you at the front.
Excellent.
Thank you, sir. In due time. Maybe. You'll be through. I'll have more to do. Oh, you can leave me. I can figure it out.
Mr. Ashmore, oh, that and then.
Mahar Hamden.
That's just gonna be-
Mr. Ashmore, we're bringing Mahar Hamden up.
No problem, Judge. Thank you.
Yes.
All right, this is cause number CR 1576, State versus Mahar Hamden, motion to adjudicate. Mr. Ashmore, are you there?
Judge, a quick announcement today. Mr. Woodwike and I were perhaps a little overly optimistic about being able to work this out. We're not that far apart. There's an immigration concern that has been raised to me by my client's family that he does not have status, and my concern is that I need to run a few inquiries to be able to properly educate him. We also have a language barrier. He is I think Farsi. I know it's Persian dialect, but that's English is not his native language. I'm not really sure about the admonitions he got before because it was a deferred probation. There were probably assurances that wouldn't interfere with status, but a straight probation conviction, which is what the state's offer is I think going to change, even if it's a nonviolent offense. I think it's going to change status. I mean, it seems to change with, every couple of years of congressional administration. So that being said, I'm asking the court for a reset so I can get that information, properly admonish my client, have his family assist in the translation, and then take one last run with the state at whether we can do something that's not a straight probation conviction, which might ultimately interfere with his immigration status. And I conferred with Mr. Woodwike on that, and I do not believe the state opposes that request, Your Honor.
That's correct, Your Honor. We would be unopposed to a reset to allow Mr. Ash more time to seek specialized legal counsel regarding the immigration consequences so he can fully advise Mr. Hamdan as to those repercussions and how to best proceed on this.
Okay, set it on the contested hearing on November 29th.
Yes, Judge.
All right, Mr. Hamden.
Thank you, Judge.
Hearing on November 29th at 1:30.
Much appreciated, Your Honor.
All right, thank you, Mr. Ashmore. Good to see you.
Good to see you. Good afternoon, y'all.
All right, state, I believe.
I thought we were about to go, and then I was like, oh yeah, we never saw Mr. Ashmore. And then you called him up and I was like, oh, we were so close. We were almost out.
Getting close. All right, so I think that's everybody that I'm showing. Stella, you too? Did you see anybody else?
Austin Hensley.
Austin Hensley.
Just they just not meet with anyone.
Let me see if that was agreed. Hensley, you know what? I don't have anything written on Austin Hensley and Mr. Schmidt. So we'll just have to we'll leave that pending and Mr. Schmidt can get that rescheduled.
That works for the state, Your Honor.
Okay. All right. We'll be adjourned. Y'all have a good afternoon.
Thank you, Your Honor.
What's left of it? Night by this time.
Bye.
No overtime for y'all.
You don't get to decide that no more.
Salary, your salary. I say it because the law says it.
Oh,